May I please? Lord, before the petitioner starts, Lord, we had something to say on the scope of the reference, not obviously on the merits of the case. Lord, I have already circulated, my Lord, my note on that. And my Lord, all on this side, my Lord, are ad item, my Lord, to persuade your lordships. Lord, the last point first. In our understanding, I'm sorry, my Lord, my apology. Lord, as per our understanding, what is referred for your lordship's consideration of 9 honorable judges is interpretation of Article 39 small b and not Article 31 capital C. And my Lord, these are, my Lord, the broad grounds, my Lord. I'm just...
But 31C, even that issue of revival will arise, right? Because that has
it will not arise, my Lord. That's what, my Lord, I would wish to, my Lord, point out. Kindly have a look at, my Lord, my note, which is 2B.
Volume 2A.
2B, 2 capital B.
Yeah, 2B comes arise.
2B, my Lord, Roman 2, capital B. It's a separate volume, my Lord.
Sent yesterday.
It was sent yesterday, my Lord. 2B, my Lords. 2A is additional written submissions of respondents. 2B is short note on behalf of...
In fact,
We're just uploading it.
Yes.
So on a lighter vein, on this side, you are trying to make our task easier by saying that there's only one issue and not...
So that's how, my Lord, our understanding of, my Lord, the chronology is.
And then go to the reference.
Right.
That's the referring order also, if your lordship looks at it. It's only the issue referred is that
if the
material resources of the community, whether they include private property or not.
if the learned solicitor permits, let us.
That issue will arise
That's right.
if we come to the conclusion that 31C is revived. Right. Right. Because
That's a
31C,
separate,
just
I'm not saying your lordship is right. Issue is there, but that's not referred because that's already covered by so many judgments.
The question is the ambit of 39B will arise provided 31C exists today. If 31C does not exist, then there's no question about the ambit of whether that will include
39B, my Lord, can still survive, my Lord. It's an independent provision as a directive principle. The only
31C, I would say.
But that's not referred.
Correct,
Once
Lord.
they expand the reference, that's another thing, but it's not referred.
It's in fact covered by the NJC judgment, because if there were no doctrine of revival, half the judges of our court wouldn't be here today.
No, but otherwise, my Lord, just a little,
It's covered, they've considered it.
my Lord, suppose,
Anyway, now the note is uploaded. so we
my
can
Lord,
just
please
see what
kindly
is
come to, my Lord, para 2, at page 2.
page 2.
Page 2, my Lord. Lord, this was the 1996 Property Owners Association, the first judgment I am referring to. I am not reading everything, para 2. The said reference, it was argued by the petitioners that Article 31C does not survive in the Constitution anymore. Your Lordship, sir. Anymore after the decision in Minerva Mills. On the contrary, it was argued on behalf of the respondent that only a portion of 31C, as inserted by the Constitution 25th Amendment, was declared unconstitutional in the judgment in Keshavanand Bharti, and remaining portion would remain. But I'm pointing out that the court was conscious of these two provisions and a possible interlinking. Lord, thereafter, your lordships may come to, my lord, 3 sub-third paragraph, my lord, the unnumbered paragraph. The judgment in Minerval Mill struck down section 4 of the Constitution 42nd Amendment on the basis of the same and subsequent judgment in Vaman Rao, Sanjeev Coke Manufacturing Company. It was argued that it was obvious position in law that 31C, as it stood after the judgment in Keshwanand Bharti, would remain in force. In essence, the argument of the petitioner at the same time was that the doctrine of revival, as it applies to ordinary statute, would not apply in India to constitutional amendment, and their subsequent declaration as unconstitutional on the touchstone of basic structure of the constitution, etc. Lord, please come to para 5. When the said matter came up for hearing before 5 honorable judges in the judgment reported in Property Owners Association, or I have given the page numbers, rather than dealing with the question raised concerning application of doctrine of revival and its applicability to constitutional amendments in India, which had a bearing on Article 31C, the court dropped the said issue and referred a separate issue to a bench of not less than 7 judges. But I have quoted from that honorable 5 judges bench. Having heard the counsel at length, we are of the opinion that the views expressed in Sanjeev Coke require reconsideration. Keeping in view the importance of the point in issue, namely the interpretation of Article 39B, it will be appropriate if these cases are heard by a larger bench of not less than 7 judges. My lord, then it comes, my lord, before the honorable 7 judges, my lord. My lord, 7 judges, my lord, in state of Karnataka versus Raghunath Reddy. My lord, there were 2 opinions delivered, my lord. One by my lord Justice Utwalia, my lord, who was in majority 4, and minority by Justice Krishna Iyer. But Justice Utwalia categorically notes that though we are not touching this issue, we are not approving or we are not concurring with the minority view merely because we have not touched upon, may not be treated as our having concurred with that view. Now, para 7. The reference of 5 judges in Property Owners Association, that is 5 honorable judges, therefore notes that the judgment in Sanjeev Coke has adopted the interpretation of Article 39B as provided by Justice Krishna Iyer in Raghunath Reddy on the basis of the same. I'm so sorry. Ranganath, my apologies. Ranganath Reddy. On the basis of the same, the 5-judge bench in the Property Owners Association opine that the views expressed in Sanjeev Coke concerning the interpretation of Article 39B requires reconsideration and only refer the said issue to a larger bench of not less than 7 judges. Now, my lord, 7 judges, my lord. Para 10, your lordships can come to. During arguments before the said bench, a judgment of 9 honorable judges in Mafatlal Industries was highlighted on the issue of interpretation of Article 39B. After taking note of the same, the 7-judge bench at para 5 referred the following question to a bench of 9 honorable judges. Having given due consideration, we are of the opinion that this interpretation of Article 39B requires to be reconsidered by a bench of 9 learned judges. We have some difficulty in sharing the broad view that material resources of the community under Article 39B covers what is privately owned. Therefore, the only issue before the present bench is whether the phrase material resources of the community under Article 39B covers what is privately owned. Despite the said obvious position, the petitioners have in great detail made submissions on whether 31C survives or in the constitution or not. Well, that's why, my lord, I am pointing this out at the outset. Their written submissions, my lord, give details. In this regard, it is submitted that apart from the fact that said issues stand concluded by multiple judgments of this court, including judgment in Keshwanand Bharti, which specifically upheld Constitutional 25th Amendment Act, it is clear from a reading of reference order of 5 judges and 7 judges in present proceedings that the said issue has not been referred to a larger bench of 9 judges. Then 13. The petitioners have in great detail further placed the challenge to a new provision of MHADA Act and specifically Chapter 8A of the said Act. It is submitted that constitutionality of a state act and individual provisions of the said act, which would involve application of various other constitutional principles and fundamental rights, it should be, may not be adjudicated by a larger bench of 9 judges, as the same may have grave repercussions, etc., etc. And at the end, page 16, my lord, this is what, my lord, our understanding of the reference is. Page 16, my lord. Only issue concerning the interpretation of Article 39.
Just 1 second, you'll just be taking us. Page 16 or?
1/6, my lord.
Page 16? Page 16.
16, my lord. Page 16 is our understanding, my lord, of the reference, my lord.
Therefore, it is submitted.
Therefore, it is submitted that only issue concerning the interpretation of Article 39B and whether the phrase material resources of the community includes private property or not has been referred to the present bench of 9 learned judges. The interpretation of Article 31C or its revival or non-revival has not been referred, and the validity of this act is, my lord, not referred, my lord, because I believe Bengal also has a similar act and they are also here.
Intervention by Bengal.
So they would also, we will be supporting on.
Mr. Solicitor, let's go in the reverse way. We'll tread the path of least resistance. Insofar as C is concerned, where you say don't decide the validity of the MHADA Act in a combination of 9, that there may be some substance in what you say, subject to hearing the other side, of course, that will turn upon, analyzing the individual provisions, looking at the impact of various decisions, and ordinarily that's always left to the regular bench.
Regular benches.
That's one aspect. Now, coming to B, we see that.
Would your lordships like to read the reference order, my lord?
Just the reference order immediately. But according to you, look, the fact that 31C, the principle that 31C in its original form stands revived as upheld in the 25th Amendment, upheld in Keshwananda. That is now, according to you, that has been the position in our law. Don't unsettle it, because you want 31C to remain there. As a government, obviously, we understand why.
Otherwise, also, my lord, kindly take it absolutely logically without going into the merits. Suppose someday, after 40 years, some mad parliament
because
deletes part 3.
Because if we come to the conclusion that 31C does not stand revived, then of course that will affect a whole lot of legislation.
My lord, suppose I am giving a very extreme example. My lord, suppose some parliament, in its wisdom or lack of it, deletes part 3, the deletion comes before your lordships. Your lordship sets aside the amending act. Now, would there be a vacuum? The answer is no. The fundamental rights will come back. The part 3 will come back. It's as simple. But kindly
That's
come
the
to
point to be considered.
Right.
yes,
That is-
but volume 5.
If I may
Not volume
submit,
5, the reference order.
Can
Let-
we do this?
if I-
Now, let's hand it over to Mr. Parekh.
No, only-
You've got your point. Let him read the reference order and then tell us
Lordship,
whether both these
absolutely.
issues arise.
Let me just place what the issue is, what are the reference orders, how it comes
You've
here.
got your point now,
Lordship.
but let's not preempt his argument. He can make that argument. Once he makes an argument on the scope of the reference, we feel that we should allow you at that stage to respond to him. We'll call upon you briefly.
Certainly.
What is sought to be suggested additionally, that if this court were to hold that 39B is confined to only natural resources and not to any other resource, then the 31C argument may not be necessary.
No,
Unless the court crosses this.
No.
if the contrary is held,
Yeah.
then
Our court has said that, well, 39B would not appear to cover private property, where the material resources of the community would extend to private property or otherwise.
tentatively, my lord, reference does similar.
That's right.
We are not able to subscribe to that view. That's what my lord is saying.
But let's hear Mr. Parekh, so let him open and then we'll get back to you.
Certainly.
Lordship, I'm grateful. In fact, State of Maharashtra first filed detailed submissions on all the issues, then Wiser Council probably prevailed. They've withdrawn that and now filed this note. Lordship.
Hold it again.
Lordship. So may I just indicate, my lords, just to start with just a little background, and I'm appearing in 6 petitions before my lords, which challenge. 5 of them challenge Chapter 8A. We are in appeal, and there's an independent
So
review.
you will be the argument, the initial argument with the 6th matter.
Lordships.
Then
Lordship.
who will follow Mr. Adhyatna? You will be
Mr.
arguing,
Adhyatna and Mr.
I am addressing your lordships on 2 issues. Lord, actually the issue of 31C. Lord, I have three broad ways I've prepared. I want to give your lordship a brief legislative history of it. I wanted to point out why my learned friend, the Solicitor General, is in fact incorrect. Lord, the question of 31C arises both as a point of reference. It arises out of the Colio case, which is expressly referred to.
It arises out of?
Colio case. Coelho. But my learned friends repeatedly correct me on the pronunciation, on the Coelho case. And it even otherwise arises squarely, Lord, in this constitutional challenge, as I will show you, Lordship. So, Lord, the reference point is the least of.
We were only on what is the lineup of counsel on your side, so it's going to be then.
My lord, we are sharing the submissions. I'll be going on two aspects of the matter, my lord. The first aspect of the matter is, can they at all seek the protection of 39C in view of the proviso to 39C?
All right.
I'll be arguing. Those are the points which I-
We just want to know who are the counsels.
Yeah.
We know about
We are-
time and everything. So
Yes,
that-
just so that it's clear to your Lordship also. Lord, Mr. Parekh's, Lord, is giving the opening remarks. Lord, he will take about 1.5 hours. Lord, subject to what happens here, Lord, he might take your Lordships to lunch. Lord, after
Then
that,
you will- after lunch you
Lord,
will
I am
start.
proposing to start after lunch.
All right.
And Lord, my rough estimate is 2 sessions,
All right.
roughly.
My lord, I'll be opposing the intervention application of state of West Bengal.
All right.
Sorry to interrupt. I'm appearing in one of the.
Why don't you all do this? Put your appearances down on a slip of paper and give it to the court master so that he'll circulate it to all of us.
The matter arises from the West Bengal case. While it was pending before 5 judges bench, the bench itself said that it would take up our matter after this
After this.
reference is over. And therefore, we want to intervene.
All right.
My lord,
Anyway, my lord,
there's one-
so far as states are concerned, my lord, everyone, my lord, assistance coming from everyone. I am not opposing state
My
of
lord,
West
there is
Bengal
one-
or any state's intervention.
which I would like
Assistance
for
should.
kind consideration. I will come. What I say.
Sorry, not right now. You know.
11th schedule and 12th schedule.
Please sit down. I will hear Mr. Parekh first.
Just, my lord, just to begin with, just to give a little summary of what are the issues and what is under challenge. There are 6 matters.
The microphone.
I'm grateful. So there are two sets of challenges. One relates to Chapter 8A of the MHADA Act in Maharashtra. It relates to the island city of Mumbai now. And the second challenge is to the Maharashtra Rent Control Act, which is in writ petition 660 of 1998. And one of the reasons, of course, why we filed a writ petition is that there is an earlier judgment of this Honorable Court, Malpe Vishwanath Acharya, which has already held that the Bombay Rent Control Act was void, the provisions relating to rent. And following that, the court adopted a method where they did not strike down the act, but stated that a new act should be formulated, which was in the process, and specifically holds that if the new act does not take care of the issues raised in Malpe, then the new act would also be void. So that's the background.
The Maharashtra Rent Control Act is in writ petition, you said 660 of?
660 of 1998. Now, my lords, we had in fact the two matters, Malpe Vishwanath and this one, actually were tagged together at one stage. They were de-tagged and the Malpe got decided. And this, of course, is still awaiting my lord's decision. Now, just to give a background, these petitions relate to temporary provisions which were brought in during World War II, 1939, first with effect from 1st January 1939. They've continued all these time. There have only been, so to say, 2 increases in rent, while the wholesale price index, and we've given that data, has risen from 7 to over 1,000, but the rents have remained frozen. Before Malpe case, there was only 1 increase of 5%, plus some increase relating to repairs which were carried out, etc. And thereafter, once the Maharashtra Rent Act has come in, then another 5% provisions are there. Now, because the rent lot.
Our court followed Justice Venkatramaia's dictum in Motor General Traders,
Bloodshed.
saying that a law which is valid on the date of its enactment
Bloodshed.
may cease to become valid by a flux of time.
Bloodshed.
And therefore, they said that a World War II law which froze the rents as of 1/9/1940
Bloodshed.
would cease to have validity by just the lapse of time. You can't deprive landlords of the right to demand fair rent.
Wait. Bloodshed.
And the court gave a certain time window.
Correct.
That's when the Maharashtra Rent Control Act came.
Correct.
They took the cutoff date as 97, right?
They took, but because 97, 87.
The cutoff date is 87.
87, but a 4% increase every year.
Correct. Bloodshed. But because the rents were already frozen for the premises, it actually went back to January 1939, because from 39 to 87, there had been no change, except one increase of 5%. So that's a broad challenge. And in fact, so that's the Rent Control Act. And if I succeed on that, in fact, my second challenge becomes easier, because Chapter 8A provides that if 70% of the occupiers decide to acquire the property, then they have to pay 100 times the rent of the property, monthly rent, not even yearly rent, pay 100 times the rent, and you become the owner of the property. And it's occupier, not even tenants. And we'll, of course, make our submissions on that. Now, if I succeed on the rent control and the rent is invalid, then possibly my challenge to 8A becomes much easier. On 8A also, I'll, of course, independently make my submission. Now, my lords, this matter comes through before your lords' 9-judge bench combination by 4 reference order. First, 2 judges referred it to 3-3-2-5, 5-7, and 7-9. So may I just very quickly indicate, before briefly indicating the facts, the 3 reference orders. First one gives no reason, so I'm not taking my lords to that. The first one from 3 to 5 is 1st May 1996. And if my lords has volume 5 of the convenience compilation, it starts at page 2787.
Volume 5, page 2787.
Gotcha.
(1996).
4 SCC, page 49.
So the volume 5, page 2787.
Gotcha. Hello, just paragraph 1 on the next page. One of the main questions for decision in these matters pertains to the constitutional validity of Chapter 8A inserted in 1986 in Maharashtra Housing Area Development Act. We all call it MADA, my lords. Hereafter referred to as MADA Act, providing for acquisition of certain properties on payment of 100 times the monthly rent for the premises. These properties are mainly buildings which were first let out prior to the year 1940 on monthly rent, which the owner claimed is a measly amount of current value of property in Bombay and the present value of the rupee. Section 1A was inserted in the MADA Act in 86, and it contains a declaration that this act is for giving effect to the policy of the state towards securing principles specified in Clause B of Article 39 of the Constitution of India. Article 31C of the Constitution is therefore retracted for excluding the attack to the validity of the enactment on the ground of Article 14 or 19 of the Constitution. My lord, if I may just give a few comments while reading this. 21 is not protected under this. Similarly, 300A is also not protected. So we will be making submissions on that. And also 31C, my lords, now in Kesare matter is laid down that the reasons must be given to the president, because that presidential approval is required for 2 reasons. One is because there is a conflict between a central law and the state law. In fact, 3 laws in this case, including Transfer of Property Act. So you must indicate to the president why you are seeking consent. And if that indication is not there, that presidential consent is not valid, in this case, no material has been produced, and we'll be making that point. My lords. Para 2. In order to circumvent the effect of Article 31C of the Constitution, Nariman, the learned counsel for the petitioner, contended inter alia that 31C does not survive because of the events subsequent to the decision in Keshwananda Bharti. Shri Desai, the learned counsel for the respondent, replied to those arguments by contending that 31C as originally enacted minus the latter part which was declared to be unconstitutional in Keshwananda Bharti as it upheld in Minerva Mills, excluded any attack on the constitutional validity of the enactment. Both the learned counsel had submitted synopsis of their rival contention in the form of written submission. A brief history of Article 31C would help to appreciate the rival contentions. Article 31C, as originally enacted, was inserted in the Constitution with effect from 20th April to 1972 by Section 3 of the Constitution, 25th Amendment Act 1971. The constitutional validity of Article 31C was examined in Keshwananda Bharti, which was decided on 24/4/1973. At page 1001 of SCR, the conclusion of the majority opinion are summarized, wherein conclusion number 5 is the second part of Article 31C, namely, and no law containing a declaration that it is for giving effect to such policy shall be called in question in any court on the ground that it does not give effect to such policy was declared to be invalid, while the rest of Article 31C was upheld as valid. Thereafter, with effect from 3/1/1977 by the Constitution 42nd Amendment Act, Section 4, the word the principle specified in clause B and C of 39, the words all or any of the principle laid down in Article 4 were substituted. Then on 15/5/1978 was introduced in Parliament, wherein clause 8 was to amend Article 31C to restore it to the position prior to the amendment by the Constitution 42nd Amendment, in the form as it stood as a result of the decision in Keshwananda Bharti. However, clause 8 of the bill was dropped after debate in Parliament, and this attempt of the Parliament was abortive. Then came the decision in Minerva Mills. The operative part of the order in Minerva Mills was pronounced on 9/5/1980, and the reason for the same were pronounced on 31/7/80. The basis of which decision in respect of 31C was rendered in Minerva Mills as is indicated in para 24. The next question which we have to consider is whether the amendment made by Section 4 of 42, amendment to Article 37(1) of the Constitution, is valid. Mr. Palkiwala did not challenge the validity of the unamended Article 31C, and indeed that could not be done. The amended Article 31C forms the subject matter of separate proceeding, and we have indicated therein that it is constitutionally valid to the extent it was upheld in Keshwananda Bharti. In Minerva Mills, Section 4 of the Constitution 42nd Amendment Act was held to be invalid, and decision was rendered on the basis that 31C continued in the form in which it existed as a result of the decision of Keshwananda Bharti. The next decision in Vaman Rao, wherein the operative order was pronounced on 9/5/1980 and the reasons were pronounced on 13 November 80, these are reported in 1980 so and so. In Vaman Rao, also Minerva Mills, it was assumed that 31C as it stood prior to its amendment by the Constitution 42nd Amendment as a result of the decision in Keshwananda Bharti stood revived. The decision in Sanjeev Cook versus Bharat Cooking Coal. Even though in Sanjeev Coke there is criticism of the majority opinion in Minerva Mills and expression of broad agreement with the view of Bhagwati J as he then was, in that decision, the judgment proceeds on the basis that 31C stood revived. If I may turn to the next paragraph and come to just the last 2-3 lines, if my lords permit, or should let me just read the whole paragraph. One of the submission of Sri Nariman is that the doctrine of revival as it applies to ordinary statute has not been applied in India to constitutional amendments. On this basis, he contended that clause 8 of the bill, 88 of 78, which was to revive 31C as it stood as a result of Keshwananda Bharti, having been dropped in Parliament, 31C as it stood as a result of Keshwananda Bharti, did not stand revived when the amendment was made to the Constitution 42nd Amendment 1976, with effect from 3rd January 77, was later struck down. He contended that the decision in Minerva Mills proceeded on the basis of a concession made by Mr. Palkiwala and on an assumption that 31C as it survived as a result of Keshwananda Bharti stood revived after subsequent events. He submitted that that is not the decision in Minerva Mills, since the question neither arose nor was it the decision therein, and decision in Vaman Rao and Sanjeev Cope also proceeded on the same basis. He contended that 31C does not therefore survive in the Constitution and benefit thereof is not available to exclude the attack to the validity of MADA Act on the ground of 14 and 19 of the Constitution. Several other arguments were advanced by Sri Nariman related to his contention. Mr. Nariman also referred to the word Constitution shall stand amended in accordance with terms of the Bill 368(2) to support this contention. Sri Nariman also contended with reference to certain decision that such a question relating to a provision in the Constitution cannot be bypassed on the principle of stare decisis. Shri Ashok Desai, on the other hand, contended that the matter stand concluded by the decisions of Minerva Mills, Vaman Rao, and Sanjeev Kaur, wherein the revival of 31C as it stood as a result of Keshwananda Bharti was not even disputed, because that is obvious position in law. He also contended that there is nothing in 368(2) to support the contention of Shri Nariman. Shri Desai also submitted that it is too late to consider this question when this is how 31C has been understood for years. The details of the arguments are both learned counsels in the form of synopses of written submissions are on record. The question is whether these points which have been raised by Shri Nariman should be considered and decided by a larger bench of at least 5 judges. Shri Desai submitted that since these contentions have no substance merely because related to interpretation of certain provisions of the Constitution, is no ground to require hearing of the matter by a bench not less than 5 judges. Having heard learned counsels for some time, we have formed the opinion that it would be more appropriate for a bench of not less than 5 judges to consider and decide these questions for an authoritative pronouncement on the same. The decision in Minerva Mills, Vaman Rao, and Sanjeev Kaur are all by a bench of 5 judges. The question in the form it is raised by Shri Nariman did not arise for consideration in any of those decisions, which were rendered on certain premises as indicated therein, which assumption is now seriously challenged by Shri Nariman. Even it is assumed that Article 145(3) of the Constitution is not attractive, it does appear to us that in order to settle the controversy on this point, which is of some significance, and to avoid the questions being re-agitated before another bench of less than 5 judges, the more appropriate course is to refer the matter for being heard and decided by a bench not less than 5 judges. For the aforesaid reason, we direct the papers be laid before the learned Chief Justice for constituting a larger bench of not less than 5 judges. Now, my lords, this is the first reference, and then the matter did come up before 5 judges, and that is now reported at page 3150 of volume 5 as 2001 4 SCC
2001.
4 SCC page 455
Get it in volume 5A.
3150. Again, a short order of 2 pages. I can just quickly read them. Again, the background is given. Lodge. My Lords has volume 5, page 3151,
This is the second.
para 1.
3151, right?
Lordship starts at 3150 at 3151. Gotcha. In these cases, the main challenge is to the constitutional validity of Chapter 8A, which was inserted in 1986 in the MADA Act in 1976, which inter alia provided for the acquisition of certain properties on payment of 100 times the monthly rent for the premises. By the said amendment, Section 1A was also inserted in the Act and contains a declaration that Act is for giving effect to the policy of the state towards securing the principles specified in Clause B of Article 39 of the Constitution of India. In view of Article 31C of the Constitution, the contention of the state was that the validity of any part of the statute on the ground that it violated Article 14 or 19 of the Constitution was not permissible. The case was heard by a bench of 3 judges. At that time, on behalf of the appellant, a contention was sought to be raised inter alia to the effect that 31C did not survive because of the events subsequent to decision in Keshwananda Bharti case. It was also submitted before the bench that the doctrine of revival as it applied to ordinary statutes did not apply to the constitutional amendment, and when a part of the 42nd Amendment which amended 31C had been held to be invalid, it did not result in the automatic revival of the unamended 31C. In view of the aforesaid contention which was raised by the order of 1596 reported in so-and-so, the matter was referred to a larger bench of not less than 5 judges. We heard the counsel and led on various issues which arise in these cases. One of the points which arises for consideration relates to interpretation of 39B of the Constitution. In state of Karnataka versus Ranganath Reddy, validity of the Karnataka Contract Carriage Acquisition Act 76 was challenged, and the question which arose was whether the state government could acquire and then transfer countersigned portion of the interstate permits to Road Transport Corporation. 2 judgments were delivered. In that case, Justice Krishna Iyer J, for himself and 2 other learned judges, while concurring with the decision in Utwalia J, with whom 3 other judges agreed, interpreted 39B of the Constitution and then came to the conclusion that the Act had direct nexus with 39B, and by virtue of Article 31C, its validity could not be challenged on the ground of it being violative of Article 14, 19, 1F of the Constitution. Utwalia J in this judgment observed that we do not consider necessary to express any opinion with reference to Article 31C read with Clause B and C of Article 39 of the Constitution. Our learned brother Krishna Iyer J has prepared a separate judgment specially dealing with this point. We must not be understood to agree with all that he has said in his judgment in this regard. The need to interpret 39B again arose in Sanjeev Coke versus Bharat Coking Coal. While upholding the validity of coking coal mines, Nationalization Act 1972, the 2 other connected enactments, the Constitution bench adopted the interpretation of Article 39B as enunciated by Krishna Iyer J in the Ranganath Reddy case. This interpretation has also been followed by a division bench of this court in state of Maharashtra versus Basantibai Mohanlal Khetan. The interpretation put on Article 39B by Krishna Iyer J in Ranganath Reddy case was not specifically assented to in the majority decision, but in Sanjeev Coke it is observation in the judgment of Krishna Iyer J which has been followed. Having heard the counsels at length, we are of the opinion that the views expressed in Sanjeev Coke case requires reconsideration, keeping in view the importance of the point in issue, namely the interpretation of 39B. It will be appropriate if these cases are heard by a larger bench of not less than 7 judges. The papers.
Now it's very clear. Ranganath Reddy, the occasion for a reference to 9 judges arises because Ranganath Reddy was a decision of a bench of 7 judges. You had the majority judgment of Justice Untwalia, concurred in with on behalf of 3 other judges, that makes it 4. And Justice Krishna Iyer, concurred in with by 2, that makes it 3. The majority judgment says that there are certain issues which have been dwelt with on by Justice Krishna Iyer on the interpretation of 39B and C. We should not be read as having accepted his interpretation. Justice Krishna had specifically held that material resources of the community will also include private property.
Lordship.
Right? So 4 judges said they are not expressing any view on what has been held by Justice Krishna.
Correct.
Therefore, the occasion for a reference to 9
Correct.
arose because clearly the views in Sanjeev Coke, which follows Ranganath Reddy,
Correct.
is something that this bench of 5 judges doesn't agree with.
Correct.
But they had to refer it to 9 for the reason that Ranganath Reddy
Or 7.
is 7.
Lordship.
And in Ranganath Reddy, though it's a view of the minority on the
Lordship.
interpretation of 39B,
Lordship.
that is something that has been followed in Sanjeev Coke.
Absolutely.
If you look at this now, it's very
Correct.
clear
Lordship.
that the ambit of the reference to 9 judges is squarely only on the content of 39B.
Lordship. So, Lordship is right, but there is something more that happens which I'll just indicate.
Whether 31C continues to subsist or not,
Lordship.
or whether it has been revived, is not
Lordship.
something which has been referred to us at all.
Lordships, I'll indicate there's one more reference order, and I'll just indicate it also refers to IR Coelho, which was then pending before 9
Let's
judges.
see that.
I'll just indicate, my lord. So my lords may have the final. So this one is laid before 7 judges, and my lord recalls that time the understanding was that you could only refer it to the next larger bench. But my lords may now come to 2013 7 SCC 522, which is the final reference order, which is in volume 5, page 3409.
By 7 judges?
Lordships, 2013, volume 7, SCC 522,
2013.
volume 7, SCC 522. At volume 5, page 3409 PDF.
409.
Lordship. May I just start first? Bench of 5 learned judges is referred to 7. Put shortly, the question is as to the interpretation of 39B of the Constitution, which speaks of the distribution for the public goods of ownership and control of material resources of the community. In state of Karnataka versus Ranganath Reddy, 2 judgments were delivered. In the judgment delivered by Krishna R.J., speaking for himself and 2 other judges, the view was taken that material resources of the community covered all resources, natural and man-made, publicly and privately owned. The other judgment delivered by Utwalya J. on behalf of himself and 3 other judges did not consider it necessary to express any opinion with regard to 39B. It was, however, made clear in this majority judgment that the learned judge did not subscribe to the view taken in respect of 39B of Krishna R.J. The view taken by Krishna R.J. in Ranganath Reddy was affirmed by a constitution bench in Sanjeev Coke. Now, in the course of the arguments before us, the learned Solicitor General for Union of India and the state of Maharashtra has drawn our attention to the judgment of a bench of 9 learned judges in Mafatlal. Speaking for himself and 4 other judges, Jeevan Reddy J. said that material resources of the community are not confined to public resources, but include all resources, natural and man-made, public and private, owned, is repeatedly affirmed by this court. Now, my lords, of course, we'll make our detailed submission, but this issue never arose in Mafatlal, where the question was of unjust enrichment, whether taxes, if they are held to be void, how do you return the Lordship? So,
Question of refund.
Lordship, absolutely.
Right.
So 39B did not arise at all.
5 led with 39.
Paid or not on that.
Lordship. So this issue never arose. These were just observations, and we will be submitting. This was obiter, but be that as may I continue. And reference was made to the case of Ranganath Reddy, Sanjeev Coke, and state of Tamil Nadu, L. Abu Kavur Bai. Having given due consideration, we are of the opinion that this interpretation of Article 39B requires to be reconsidered by a bench of 9 learned judges. We have some difficulty in sharing the broad view that material resources of the community under 39B covers what is privately owned. Now, my lords, next paragraph is important. Given that there is some similarity in the issue here involved and in IR Coelho versus State of Tamil Nadu, which already stands referred to a larger bench, preferably of 9 judges, we are of the view that these matters should be heard by a bench of 9 learned judges immediately following the hearing IR Coelho. Now, I have to indicate this. Coelho has nothing to do with 39B. The issue there was, even though it's been put in the 9th schedule, are 14, 19 and 21 available to the extent they affect the basic structure. And there are observations there which my lords may consider in this matter also on 31C also, which says even though you put it in the 9th schedule, the trinity of rights under 14, 19, 21 can still be taken for the purposes of challenging a particular law, a specific law. So there, of course, there was a constitutional amendment to add it to the 9th schedule. Here, despite 31C has no such provision, there are observation in Coelho which says that I can still challenge, and therefore we'll be pressing that point also. That despite the fact, even if my lords holds that 31C survives, that it's protected by 39B, my right to challenge under the trinity of 14, 19, 21 still survives, which is what Coelho has said. So we'll make that good.
Deshwananda Bharati.
Lordship.
Deshwananda Bharati, they affirmed whatever was there prior to the judgment of.
Lordship.
Incidentally, it is tomorrow, 24th of April, 73. But anything thereafter is to meet the challenge.
Absolutely, I'm grateful. But therefore, my lords have thereafter held that even acts and statutes, not just constitutional amendment, cannot be violative of the basic structure, and point out there are two direct judgments that even acts on a standalone basis can be challenged on the ground that they violate the basic structure. And Coelho, now 9 judges of my lord's court, have upheld the same. Now, there are observations that 31C also this will apply in Coelho itself, but that issue did not squarely arise here.
But if you now look at the last two orders which you have shown us,
Lordship.
the 7-judge
Lordship.
and then of 5,
Lordship.
the two orders really dwell on 39B.
Lordship.
There is really no reference to 31C.
Lordship.
Or nor is that point specifically referred to the bench of
Except in para 6, insofar as they say await Coelho. So Coelho would then be that are those rights available?
Because they probably wanted to await Coelho because another 9 judges.
Coelho must have been, my lord, on the anvil of being listed.
If it has some impact
On the anvil of being listed. That appears to be.
No, I was also appearing in Coelho. It was not on the anvil of being listed. But we pointed out that the same issue arises there in the context of 31B. That even if you put that act in the 9th schedule, you can still challenge it on the ground of violation of the basic structure. And that's the issue we raise here also, that even if it's protected by 31C and we fail in all our other contention, it is still open, and that's the short issue we want your lordships to consider.
So why does a bench of 9 have to consider that issue?
Because, in fact, the Coelho reference order explains that, but Coelho as 9-judge bench decided this issue for 31B. So we'll indicate, my lords, as we...
Very tenuous.
It is to that limited extent, yes. But my lords, we are, just give me a moment.
I mean, that is the point that I.
The 3 ways we also discussed that. May I just there are so lordships. I'll just submit there 2-3 possibilities. I'm not. Lordship, so I may just, this is what we consider, my lord. I'll just place it before you, and then you may consider as you, my lords, may.
It's not the ambit of the reference.
Lordships, I'll do that. But we thought there were three possibilities that arise in this case.
Yeah.
The 2 judgments, Sanjeev Kok and Abu Kapoor Bhai, are 5 judges. Ranganath is 7 judges. But Minerva, the Mafatlal judgment is 9 honorable judges. If my lords either can hold that Mafatlal is arbiter, then it's open to my lords to decide this issue. Otherwise, my lords may have to consider whether it has to go higher to a 11-judge bench in case my lodge is not in doesn't hold that Mafatlal was arbiter and it's clearly arbiter, will try to make that good. In which case it's open to my lodge to decide this matter is our first submission. Lodge will consider whether on Mafatlal issue, my lodge wants to consider that and will make it good that those were arbiter observation. It has nothing to do with the issue at hand. Or it should go higher. That's one issue that my lodge will decide. On 39 BNC, my lodge, we are with my lodge that if 39 BNC is decided, it can go back to 5 judges for consideration on 31C, whether it survives or not. But we would like to make our submissions on Coelho because Coelho specifically deals with the scope of challenge under 31B and C. Although 31B arose there, we do want to make our submission that the same principle will squarely apply for 31C. Because if it does, then my challenges under 14, 19, 21 are still available even for these laws, even if protected under 31C.
You can also argue that before.
We can. Lordship, we can.
3 judges or 5 judges.
I will not disagree. My lodge is right. So, but we like to place Coelho and then my lodge may take a view on my lodge.
So now how do you want to begin?
No, my lord. So we've drafted some propositions. I'll briefly indicate what all arises. Not all of this has to be decided by my lodge, but we'll just place what we wish to argue. Seeing those issues, and then if my lodge permits, I'm proposing to read the Malpe judgment and then hand it to my colleague, Mr. Jarujina. So these are the two aspects. So may I just indicate these are the issues that we feel arise. Most of them, of course, will not be have to be considered by this bench, but I wanted to place these on before my lodge. The first is whether Article 31C of the Constitution of India survives after the judgment of this Honorable Court in Minerva Mills in so-and-so, striking down Section 4 of the 42nd Amendment Act. Now, whether Chapter 8A of MADA has received the assent of the President of India is required under the provision of 31C and as decided by the judgment of this Honorable Court in Kesre, that is, reasons were given, etc. And they did not produce that. Whether the onus of proving that the assent of the President was in compliance with Kesre is on the state and whether they have discharged the burden. That again squarely arises from the pleading, but we'll make submissions on that. Now, whether the material expression, material resource of the community occurring in 39B of the Constitution would include private properties, and whether Chapter 8A of MADA subserves the purpose of 39B and is for public good. So one, because 39B has two parts, material resources for public good. So we are submitting on both. Now, whether Chapter 8A of MADA and Maharashtra Rent Act can be challenged under Article 14, 19 and 21 of the Constitution of India in light of I.R. Coelho versus State of Tamil Nadu, even if Article 31 survives. Then 7, whether MADA and Maharashtra Rent Act are invalid, being contrary to 21 of the Constitution of India. Now on that we are again, I'm just indicating the point, 21 is not protected, 31C is only for 14, 19. 21 is right to life, and there are reports of the respondents themselves, their committees, which say that there are a lot of landlords who are poor. Not all landlords are rich and not all tenants are poor. A lot of landlords have put in their hard-earned income in building a house and they're not even able to survive. All their reports, we place them on record, is what we'll be arguing.
Drive down Marine Drive, right, in Mumbai.
Lordship.
And you see all those buildings, the Art Deco buildings. They're most of them are tenanted.
Lordships. All of them, in fact.
All of them.
All of them, in fact. My lords, all. The rent of most of those apartments do not exceed 200 rupees, even today. That's it. That's it. In fact, initially they were all under 80 rupees, the Act itself notes. And now they've gone up a little bit because of taxes, etc.
But is relatable to the annual letting value.
No. There's some amount of compensation they allowed us, that's all, out of the taxes. But we are bearing the tax also, which they are not paying. The tenants are not even paying the tax that has gone up from time to time. And again, their report says that we are paying out of pocket. Most of us are in the negative.
Issue 4, 15 and 16.
Lordship.
4 you have said.
Lordship.
Whether the expression material resource of the community occurring in 39B
Lordship.
would include private property.
Lordship.
15, whether the observations in para 86 of Mafatlal is obiter dictum and not binding.
Lordship.
And 16, whether the judgment in Sanjeev Court could have upheld certain observations made in the concurring view that you are referring to Ranganath Reddy about Article 39B of the Constitution, with which the majority opinion expressly did not agree in state of Karnataka versus Ranganath Reddy.
Lordship. Lordship, so we have no difficulty, but we like to place Coelho judgment before my lords takes a final view. That's all I'm saying.
What else, Mr.
Lordship, may I just indicate what are the other issues very quickly? 8 and 9 relate to Article 300A. This is also a development after the last referent order. In Clayty Plantation now, if you take acquire property, it must be for public purposes and the compensation cannot be illusory. So on this ground also we are submitting that we are entitled to succeed. So may I skip that? 11 is again the Coelho point that I can challenge under. Then 12, whether Maharashtra Rent Act is on the face of this Honorable Court judgment in Malve Vishwanath void and is liable to be struck down. That's the argument that if the standard rent provisions go because of the prospective judgment, then MADA itself will go in as a consequence. Then whether Maharashtra Rent Act, that's the writ petition 660, again can go to a smaller bench. Whether Maharashtra Rent Act takes away the basis of Malpe Vishwanath Acharya. Then 14 is void, chapter 8A. Then my lords has already seen 15, 16. Then 17, whether chapter 8A of MADA can at all be treated as a law of public good or in the nature of land reform, or are per se illegal and violative of the basic structure of the Constitution of India as it purports to transfer property from one private person to another private person. Then whether there is any evidence to show that all landlords are wealthy and tenants are all poor. Then whether in view of report of 12th Law Commission finding that not all landlords, again it's a factual, whether the properties purchased through hard work of property owners and or their predecessors can be treated as estates like Jagirdari, Inamdari, Zamindari system which can be redistributed. Then whether chapter 8A was enacted merely as a misconceived attempt to deal with their own wrongs including inter alia freezing of rents, failure to build adequate housing, as also prevent disabling the landlord from maintaining the tenanted premises while failing to maintain the same themselves. So, my lord, these are not all the issues we are submitting before my lord. My lords, with that, I'll only point out one judgment, which is the Malpe judgment, where my lords has already dealt with the Rent Act, and then I'll request Mr. DYChandrachud to take over on 31. No, you're taking 31C, right? Sorry, that's it. Now, my lords, may just have
Arguing 39B though.
Mr. Devarajan.
Malpe judgment is only on Rent Act and its validity. Your lordship's not even, not concerned.
I'll
Not be convenient if we begin with the argument on 39B.
Lordship, we can do. Lordship, we can do that.
Of course, we'll not prevent anyone to argue the other 31C.
No difficulty.
Argument also.
No difficulty. Then would my lords want, I was only pointing out Malpe for a few facts. I can just point out those dates and then that's all I want to do. A few dates so that the rest of the submissions will make more sense in light of that.
About the relevance of Malpe, all right, what some dates
No,
you want to give us?
just dates, a few dates I'll point out.
Those dates. We just at least take them down so that we.
Lordship, they're not more than 8-10 dates, so I'll just indicate. So this whole process started on 19/6/1939 when the Bombay Rent Reservation Act froze the rent with effect from 1/1/1939.
9639, what happened?
19/6/1939, the Bombay Rent Reservation Act came. Rent Restriction Act came. This is the first law which froze the rent as on 1/1/1939.
Froze the rent as of
1st January 1939. Then there is the first Bombay Rent Act came on 12th May 1944, which is the full name is Bombay Rent, Hotel Rates and Lodging Houses Rates Control Act. Then 13th February 1948 is the Rent Act, which was then considered in Malpe judgment.
Bombay Rent Act was 12th May 1944, right?
12th May 1944 and then 13th February 1948. It was replaced by a new law. So we are concerned with 13th February 1948. Then my lord, MADA came again twice. 5th December 1977 was the predecessor MADA Act. And then the one we are concerned with is 27th April 1986, which has Chapter 8A, which we are concerned with. Now, I'll only then give the date of the judgments. Then the judgment in Malpe Vishwanath Acharya is 19th December 1997. And my lords, the last date is 1st April 1998 is the Maharashtra Rent Act. My lords, just
Judgment is on?
Malpe is 19th December 1997. And 1st April 1998 is the Maharashtra Rent Act. Just to give the broad dates so that. Grateful, man.
Thank you, Mr.
Thank you.
So, Parik, the last date Maharashtra Rent Act is?
1st April. 1st April 1998 with effect from 1st April 1998. In fact, after Malpe came, they came out with notification, extended it twice. We filed this writ petition, then they brought the Maharashtra Act and then they amended the writ petition.
So the 1988 judgment is
Yes,
with
sir.
regard to which Rent Act of Maharashtra?
Maharashtra Rent Act of 1948, right? 1948. 1948. Large.
Take up, you mean Malpe? Is it?
Malpe.
Malpe is about
Just
the
take it.
1940.
48. Large. take it there, I will come back. Bombay Rent Act is 47, not 40.
Not
47. Lodge.
Bombay Rents and Hotel
1947.
Lodging House rates down to like 47.
Lodge. I'm grateful.
Thank you, Mr. Badu.
No, it's yours.
Yes, Mr.
Lord, Lord, I have noted everything that your lordships have said. Lord, on 31C, my Lord, I just wanted to say a few words with regard to Colio, if your lordships permit. Lord, before your lordships take a decision on the reference, my Lord. Lord, of course, my Lord, whether your lordships decide to hear it now or whether your lordships refer it down, Lord, it will then go to a constitution bench of 5 judges. Lord, is a matter for your lordships to entirely decide. Lord, your lordships have seen the reference, so Lord, I'm not going to read them again. And your lordships is of course right, is that the first reference from 3 to 5, Lord, notice the 31C issue, Lord, what I'm calling the dead letter issue about whether it has revived or whether it required validation. Lord, in the subsequent reference, in one sense that was noted but not mentioned again, and undoubtedly the reference to your lordships today arises out of the last order. Now, my Lord, it's a matter of construction about how your lordships read that last order. And I quite appreciate, my Lord, the Chief Justice's point that actually the reference is on the Mafatlal judgment and the 39B point. But, my Lord, I wanted for your lordships to consider this. I'm not sure that, Lord, it has become clear in the order what exactly the significance of Colio is. Lord, I'm fully aware of the fact that your lordships are fully seized of Colio. But Lord, if your lordships will hear me on that for 2 or 3 minutes, because
Coelho, right?
Coelho only. Lord, because I believe, Lord, it has a very significant bearing on 31C and on the facts of this case. No, but I'll just summarize it first for your lordship. Lord, polio itself was a case which was referred to 9 judges. Lord, it was referred to 9 judges, and I will show your Lordship the reference. Lord, as a result of inconsistencies which were noted in the judgments of Vaman Rao between the then Chief Justice, Justice Chandrachud, and Justice Bhagwati's judgment, and also the judgment in Minerva Mills and Vaman Rao. I'll show your Lordship that. Justice Bharucha, as he was then, Chief Justice Bharucha, as he was then, but therefore referred the matter up. Lord, the question that was framed before the 9 judges in Coelho was with reference to 31B. Lord, it concerned the Tamil Nadu Act for acquisition of land. Lord, the Gudulur Janmam Acts, so on and so forth. Lord, the question was framed on 2 bases. Lord, one is the question with regard to whether 31B is valid. And the second was a question with regard to fundamental rights and with regard to the scope of fundamental rights, and in particular, Article 14, 19, and 21 of whether they are included in the basic structure. Now, my Lord, as your Lordships know, my Lord, Keshav Nanda, my Lord, has been a decision which has been constantly evolving by a process of interpretation from time to time. Lord, although, Lord, the majority in Minerva Mills came very, very close to saying that 14 and 19 are a part of the basic structure, they didn't say so in terms. Lord, they went on then to strike down the amended portion of 31C and upheld it the unamended portion of 31C. Lord, this question has now been squarely addressed, Lord, in the Coelho judgment. Lord, I'll come straight to the point, Lord. The Coelho judgment now entrenches, well, there's a little bit of controversy, I'll come to that in a bit, Lord, but entrenches 14, 19, and 21 as part of the basic structure. Now, Lord, first to put the point a little simplistically, Lord, your Lordships are fully aware of 31C. Lord, 31C is the safe harbor provision. Lord, in the event that 39B and C stand attracted, then there can be no challenge on the ground of 14 and 19. The Lordships are also aware that originally there was 14, 19, and 31. Lord, when the right to property got deleted, Lord, that was also consequently deleted. Now, Lord, if 14 has been held now to be a part of the basic structure, the real question that arises in my respectful submission to your Lordship is how effective the validity of Article 31C ruled upon in Keshav Nanda Bharti remains. And Lord, I'll just tell your Lordship why I say this, Lord. But as your Lordships are aware, Lord, in Keshav Nanda Bharti, Lord, 31C, the latter part, was struck down, the declaratory part. The first part was, however, upheld. Lord, it was upheld, Lord, like everything about Keshav Nanda Bharti, Lord, in a fascinating way. Lord, 6 of the judges who believed in the unlimited power of the Constitution to amend, Lord, upheld it. Justice Khanna upheld it on a slightly different basis, drawing a parallel with 31A. Although, as we all know, that Justice Khanna, in fact, believed in the implied limitation and the basic structure theory. Lord, that was interpreted, Lord, in Minerva Mills. It was read through in Vaman Rao, as I'll show your Lordship. And, Lord, we are now presented with the effect of the Coelho judgment. Because, Lord, the language of 31C, and your Lordship will just see the wide language, Lord, it brooks no interference with 14 and 19 rights. So, Lord, and there's a lot to be said, my Lord, with regard to how you will...
Let's read the statute.
Would your Lordship mind, my Lord?
Yeah.
Lord, if your Lordship will come to 31C.
Statute, the provision. Yes.
Lord, I have prepared a short note on Coelho also. I'll just come to that in a bit. 31C, saving of laws giving effect to certain directive principles. Notwithstanding anything contained in Article 13, no law giving effect to the policy of state towards securing. Now, Lord, this is the portion which was struck down in Minerva Mills, all or any of the principles laid down in 39(4). Therefore, your Lordship will read it in the old language, which says in relation to 39B and 37
in our books.
Yes, your Lordship is perfectly correct.
The principles specified in Clause B or Clause C of Article 39.
Perfect, my Lord. So that is, my Lord, my revival argument.
Shall be deemed to be void.
Shall be deemed to be void on the ground that... Now, my Lord, please note the sweep of this, my Lord, that it is inconsistent with, or takes away, or abridges any of the rights conferred by Article 14 and 19 Or the latter italicized portion is the portion which was struck down in Keshav Nanda Bharti. So, my lord, today, my lord, with the Kolio judgment, Lord, it is very difficult to understand what force remains in Article 31C. 31C undoubtedly valid as rule.
Then, Mr. Andarishna, if you argue that, you are virtually then asking for a reconsideration of the correctness of Keshav.
No, I'm conscious.
Do that.
No, I'm fully conscious of that. Lord, that's an outrageous argument. And, my lord, so, Lord, yes. Lord, the logical extension of the Kolio argument may take us to Keshav Nanda Bharti, that is true. But your lordships are presented with a 31C problem. I have some solutions to that. Lord, if the occasion arises, Lord, I will argue that.
Kolio was essentially with 31.
Because, Lord, what meaning is left in 31C if we say that every aspect of 14 can be used as a challenge?
But we are a bench of 9. We are bound by the principles which have been laid down in Keshav and Bharati, which upholds 31C as it was originally enacted.
Correct, sir.
And as originally enacted, 31C gave, as you rightly said, it's a safe harbor provision in respect of a challenge to the laws giving effect to the directive principle contained in 39B and C on the ground that it violates Article 14 and 19 of the Constitution. Now, that has been upheld by a larger bench of 13, or by a bench of 13.
By a bench of 13 judges.
For us, that's now a dictum. I mean, that's a given that 31C is valid.
I accept that, Lord.
Right? And therefore, there's no reason for us to go into the impact of Coelho on the correctness of the decision on Keshav and Bharati.
So, Lord, that is a very far-reaching proposition. Your lordships are right. And, my lord, against that suggestion, Lord, if at all I made it, my lord, is of course the Minerva Mills dicta, Lord, where actually they said that whatever be the case.
These walls are witness to what happened after Keshwanan, when a review was assembled in this very court, and then abruptly it was discharged. We'll not forget that history of our court. We'll now allow Keshwan to rest where it is.
No, but long may it rest in peace, Lord, undoubtedly. Lord, so, Lord,
not just rest in peace, but as a vibrant part of our discourse, isn't it? As it is today. Because once we open up the canvas, there'll be.
When we say that 6 judges are right.
Continue to guide us.
No, Lord, I don't say that. But just bear with me for a minute, Lord.
Guide us.
No, Lord, so the Minerva.
With 31C in its original form, as upheld in Keshwan, we'll see Coelho for 5 minutes with you, no difficulty.
No.
We'll treat 31C as upheld in its original form by Keshwan and Bharati to be the position which binds a bench of 9 judges. And then we accept it,
Lord, accept it, Lord. But may I just point out to your lordship, Lord, that Kolio presents a problem for your lordship, Lord, in this case, in this sense. Lord, what are we to do with Kolio if we accept the validity of Article 31C? Because, I mean, your lordship sees that it is quite obvious that 31C is now effectively emasculated as far as it comes up against 14 and 19. But 14 and 19 challenge now in view of the Kolio judgment is a basic structure challenge. Lord, assume that 31C was brought in for the first time by an amendment today. Lord, it would be beyond the amending power of the Constitution. And being beyond the amending power of the Constitution would be void. Now, Lord, I quite appreciate everything that your lordship has said, but it is a very serious issue which arises, Lord, in the context of 31C. Now, Lord, I show your lordship Kolio. But Kolio was a judgment actually under 31B, or the question framed in paragraph 5 was under 31. Correct. 9th schedule question. Lord, they don't actually strike down 31B. In fact, what Kolio veers towards is an exposition on fundamental rights. And there are some questions that arise, but one thing it does is that it entrenches these three, Lord, 14, 19, 21.
Those laws which were inserted in the 9th schedule as of the date of the judgment in Keshwan Bharati are immune.
Yes, your lordship is right.
Those laws which were inserted in the 9th schedule after the 24th of April 1973 would be still amenable to a challenge under...
but which is exactly, if your lordship recalls, what the majority also said in Minerva Mills. Which is what...
In Vaman Rao, it was sustained, this view. Cut off.
But Minerables, I'll show your lordship, Vaman Rao and Minerables, both. Now, my lord, the point that I leave your lordship with, and the point for consideration was,
You know, really speaking, why should a bench of 9 go into these issues at all? You know, the first thing you ask yourself is, why 9? What is the occasion for 9 and not 7? And the occasion for why 9, why not 7, why not 5, why not 3? Actually, you know, the reason for the constitution of a 9-judge bench is obviously because there's something operating in a 7-judge bench, which is a matter of concern. Now, actually, in this case, Ranganath Reddy, the bench of 7, has not said that 39B will include resources of a private nature, right?
Majority.
In fact, it's quite to the contrary. Justice
Right.
Upadhyay specifically in his majority opinion keeps that issue open, saying that we are not
agreeable with,
we should be construed to have agreed with Justice Krishna's viewpoint.
my lord.
The problem, yes, there's a specific paragraph on that.
Yes, my lord.
Now, the problem arose because Sanjeev Koch lifted Justice Krishna's perception on the interpretation of Article 39B and made it a bench of 5. Now, it could have been resolved by 7 also. It could have been resolved by 7 by saying that, look, what was done in Sanjeev Koch was plainly incorrect because it overlooks that the view of Justice Krishna was a view of a minority on that subject, or at least a plurality and not a majority in Ranganath Reddy. But the 7 judges thought that we should refer it to 9 only because in the meantime Mafatlal has come. And Mafatlal has that observation in para 86. Now, if we come to the conclusion that, look, that observation in Mafatlal is obiter, because Mafatlal was really dealing with unjust enrichment. There's an observation that would end the issue on Mafatlal, 1. 2, if we then construe the judgment in Sanjeev Koch to the extent of interpreting Ranganath Reddy, we'll say that the bench in Ranganath Reddy, the 7-judge bench, has not laid down this principle at all as a principle of constitutional law. Of course, we are a bench of 9. We can still look at the interpretation of 39B, whether it will apply cover private property as well. And you may argue that 39B should not cover material resources of the community cannot mean material resources of a private person. That is something which you can certainly argue before us.
My lord, I leave it up to your lordship. My lord, as I said, it is your lordship's reference.
31C argument here, you know, we're 45 minutes short of lunch. We'll all have a conversation between ourselves.
But in the meantime, yes, but I fully appreciate what your lordship says, and it is your lordship's order of reference, but it is for your lordships to decide. And of course, the 39B point can get us home as much as the 31C point as well. So, my lord, that stands.
1B is essentially
My dear.
a validation provision. They wanted to validate certain things by virtue of that.
The 9th schedule. 9th schedule.
Prejudice itself.
Yes.
So it has a restrictive scope also. 31B has a restrictive scope.
Yes, my lord, what your lordship say, my lord, what resonates with me, in fact, that is our argument. Mr. Devarajan will make it for us. My lord, that actually, my lord, it is difficult to say that private property falls within 39B. My lord, that the so-called concurring judgment, it's called a concurring judgment, my lord, delivered by Justice Iyer, Justice Krishna Iyer, where he says that I agree with everything, but it's such an important issue, so I want to say something more on it. And my lord, he then slightly extends the principle in an axiomatic way to say that actually private property is obviously a part of 39B. And as your lordships have rightly pointed out, subsequent judgments have picked up that observation which was made by Justice Krishna Iyer. And my lord, if at all, my lord, the consequence, the impact on this case, if that it is not a part of private property, my lord, then a large part of our challenge, my lord, has a good chance of succeeding. So, my lord, that is how the impact lies on our case. And your lordship's absolutely right about 39B. My lord, I don't think I can say more on 31C. My lord, your lordship's interpretation of the reference order, of course, my lord, is, my lord, perfectly correct. My lord, I had only thought that the impact of Colio was something that required consideration by your lordships. Because the problem with Colio.
Look at Coelho. Please show us Coelho.
Can I show it to your lordship?
Let's go to Coelho because, you know, we.
But in the time left, my lord, will your lordship
Yes,
just have a
certainly,
look?
let's-
My lord, I've prepared a very short note, but I wonder, would your lordship like to see the judgment itself? That might be better.
You have your note here?
I have a note where I've extracted actually, my lord, because all these judgments are so long. So, my lord, I took the liberty of making some extracts. It's uploaded.
That'd be nice.
It's uploaded.
Is it uploaded?
Yes.
Is it,
But it's, It's actually comprehensive in the sense that yes. So, my lord, if your lordship will, if my lord, the court will kindly furnish your lordship, my lord, with an email sent by my learned friend, Mr. Parekh, my lord, at 9:56 this morning.
Article 39B in that dichotomy, that 39B can never include private property. That would be very artificial because when it says material resources of the community is agnostic to title. You know, it doesn't mean that, well, where the title, it doesn't make that, distinction between a case where title vests in a private person as opposed to title in the community.
Or I see that point, right? Lordship is
So,
right.
a given case, take mines, for instance. They may be private mines, but in a broader sense, these are material resources of the community. The title may vest in a private individual, but therefore, for the purpose of 39B, our reading should not be constricted, but must have that broad understanding of 39B.
So, political sense.
Or take a case like these buildings in Mumbai. Technically, you are right that these are privately owned buildings. So what was the reason for the law? We are not commenting on the legality or the validity of the law. That will be tested independently. The reason why the state legislature came out with this was that, these were all buildings, old buildings of 1940. With the kind of monsoon in Mumbai, these buildings get, dilapidated because of the saline weather. You know it better than me. Because of the
Only
saline
slightly.
weather. That, the fact that the rents were so meager that the landlords had no motive to at all to repair them. So where will the landlord, poor fellow, find any money to repair the buildings? And the tenants were sitting tight that no one tenant would have the wherewithal to repair the whole building. So therefore, the legislature acted. So these are in a sense, what do you mean by material resources of the community? Material resources of the community would mean the resources in which the community has a vital interest. If a building falls, the community is directly affected because who dies when a building falls? The occupants die. Therefore, we must distance it from a title.
But there is no doubt that
Common good.
there is no doubt that it is not a question which is free from debate. Lord, and there is no doubt that these considerations have to be taken into account.
In bit of 39B, we have to answer as a bench.
But that is a specific point raised.
See, we were just discussing between ourselves. One way would be to say accepting what the reference order says. That look, Ranganath Reddy didn't decide this issue. Sanjeev Sok was wrong in picking up on the judgment of the minority and then treating it as a bench of
As a majority.
Principle.
Yes.
And applying it in Sanjeev Sok. But assuming we do that, then what? The point still survives. And I think with this issue, we should resolve.
No, your Lordship has to grapple with the issue substantively.
That 39B, the ambit of 39B is something which we should decide. That is the scope of the reference, in fact.
39C.
See it.
The way we take it that Mr. Devarajan would be arguing that 39B cannot include private property at all. And you would be saying that it can.
It can.
Right? But
Yes.
obviously you will be addressing us as a matter of first principle also.
Yes, of course.
You're not going to only rest it on Sanjeev Kaur because you will.
On first principles also. Lordship may decide the ambit.
Because we have to decide it.
That
We're a bench of 9.
Yes.
We are not bound by any of
So
these.
that's the reference your Lordship has to decide. And it will be better, because otherwise, again, this.
And there'll be some finality to this.
Yes.
Because what's the point in again having a ping pong bottle
That's
that
right.
will go before 7, then 7 will again have to interpret what Mafatlal meant. At least we in 9, we can at the least say that Mafatlal was orbiter.
Yes.
And then decide it. We may still come to the same conclusions. But 7 can't, then 7 will be bound by even the orbiter of Mafatlal.
So it may not be enough to say that Dalal is orbiter and leave it at that and send it back. That may not be appropriate.
We will have to decide it.
Lordship may decide.
It's desirable that
Yes, yes.
So, that means we are.
Yes. I thought we laid the cards very bare that, ultimately let's not again revisit the correctness of the constitutional validity of 31C on the basis that Coelho would have some bearing on the correctness of what Because Coelho was doing it in 31 in the context of 31B. Coelho was bound by Keshwan Bharti.
My lord, I've consulted my colleagues also. And my lord, we have no objection either way. We are happy either way. If your lordship was to hear us, we are happy. If your lordship sent me home early, I'm happy with that.
No, nothing else.
My lord, on the other hand,
As an act of judicial statesmanship, we should be very careful about,
No,
opening up a canvas which may then have untold ramifications.
No, my lord, I fully see that. I fully see the significance of the point. And we have some arguments on Coelho, which we can run.
But you have put in so much of hard work. Why don't
No,
you
my lord. I'm very happy to show.
In any case, there's something interesting.
I will show it to your lordship in a few minutes.
We'll see your note.
Yes. And my lord, just to step back from that, so my lord, our position, my lord,
You have three academically oriented members of the bar, the attorney himself, Mr. Dwivedi, in any case.
The lighter that are telling you, all of us are material resource of the community.
The only issue is not to be distributed on the private side.
I think the compliment should be paid back to the bench, my lord. But
Sources is the question.
Home for dinner.
my lord, speaking for ourselves, my lord, we are perfectly content with that. My lord, we will argue the Coelho point, my lord, before a smaller bench once your lordship takes a view on 39. There's no problem with that. My lord, we have various ways to deal with Coelho, so we can do that. There's no problem. If your lordship would like to see Coelho, well, I'm happy to show your lordship what we have. It is actually a very, very interesting issue. It is a very interesting issue for more reasons than one. I won't take more than 20 minutes.
Yeah, of course. 31B, of course, creates an immunity for acts in the 9th schedule.
Yes.
But now, how do we apply the logic of Coelho to 31C?
That is the point. Now, my lord, let me address your lordship first on that.
Yes.
So, my lord, as I pointed out to your lordship, that Coelho and the question that is also framed there is actually a question which revolves around 31B. Now, my lord, some scholarly critique and criticism of Coelho, Lord, has been precisely this, that it has not really answered the question with regard to 31B, at least to the fullest extent. But what Coelho did was to make a very clear statement on what is included in the basic structure as far as these three rights are concerned, 14, 19, and 21. Lord, I think it would be open once again to some comment about whether it actually captured everything that it said in the judgment in the conclusion. Because in the judgment, it does suggest that, in fact, there are other fundamental rights which could also be entrenched in the basic structure, but it doesn't actually pick them up in the conclusion. But the other aspect of Coelho, which, with the greatest of respect, I say to the learned judges, they've laid out a very complicated test for testing 14 against the relevant law. They've laid out two tests. One is the rights test, and the second is the essence of rights test, which they draw back to Nagaraj's case, Justice Kapadia's judgment. When those two tests will apply is also alluded to in Coelho, and it is a difficult to understand part of Coelho, where the suggestion is that the rights test, which they also call the right/impact test, will apply where an entire chapter of the Constitution is abrogated, whereas the essence of rights test will apply to an individual article which stands affected or abrogated. Subsequent judgments of your lordship's court, have been, with the greatest of respect, a little cloudy about what exactly is the scope of those two tests also. But in my respectful submission, at least one judgment has mixed up the two tests as well, as I'll show your lordship. So, Coelho itself gives rise to several questions. I fully appreciate the fact that this may not be the right forum to tackle Coelho in its entirety, but perhaps my attempt today can be to show your lordship that at an appropriate opportunity, there are some creases which need to be ironed out in the Coelho judgment.
If you're taking 20 minutes, let's look at
I'll try to quickly deal with it, my lord. If your lordship will have a look at my note. Oh, yeah, here it is. Yeah, it's it. Lord, do your lordships have my note, my lord? Lord, so if your lordship sees the index of my note, Lord, it is Roman 2. And Lord, I have tried to make it comprehensive with regard to what I want to say with regard to Collier. I just want to show your lordship after that, my lord, 1 or 2 paragraphs in Collier, my lord, which are of particular significance. My lord.
Yes.
Lord, in paragraph 1, my lord, I've just set out, my lord, what your lordships have already read. Now, my lord, in paragraph 2, my lord, I've dealt with the ref.
Yes, Mr.
Lord, paragraph 2, my lord. So, my lord, first is the reference in Collier. Why was it referred? The judgment in IR Collier.
Para 2, right?
Yes, para 2, if your lordships don't know. But it's at page 27, pagination, top right-hand side. It looks like something like this.
Yes. Just go to para 2.
To para 2.
Yogesh, go to para 2.
So, my lord, we are on para 1. I follow, my lord, we can follow it here. Please scroll down to paragraph. Yeah. My lord, the judgment in IR Collier, notice that there were apparent inconsistencies in the judgment in Vaman Rao and Union of India, in particular between the judgments of Chief Justice Chandrachud and Justice Bhagwati. See paragraph 3 of IR Collier Supra. Accordingly, the 5 judges in IR Collier stated that the judgment in Vaman Rao needs to be considered by a larger bench so that the apparent inconsistencies therein are reconciled and it is made clear whether an act or regulation, which or a part of which is or has been found by this court to be violative of one or more of the fundamental rights conferred by Article 14, 19, and 31 can be included in the 9th schedule, or whether it is only a constitutional amendment amending the 9th schedule that damages or destroys the basic structure of the Constitution that can be struck down. So, your lordship notes the question as formulated. It's slightly changed when the 9 judges actually dealt with it. Further, the 5 judges in Collier also noted that the decision in Bhimji Singhji case will also have to be considered by the larger bench for the purpose of arriving at a conclusion aforementioned. Now, just by way of a temporal context, your lordship is aware, Lord Vaman Rao, Minerva Mills, Lord 1918. Lord Minerva Mills, July 1980, Vaman Rao, November 1980. Lord
Alternative order pronounced on the same day, 9th May 1980.
Exactly. My lord, interim order pronounced on the same day, reasons given separately, but one before the other. But unusual of great academic interest for various reasons, my lord. Magisterial dissent by Justice Bhagwati in Minerva Mills, picked up as Sanjeev Kok, as your lordship notes. Lord Vaman Rao, my lord, deals with the unamended Article 31C, upholds it not because of Keshav Nanda Bharati, but on independent reasoning, which is in parity with upholding Article 31A on agrarian reforms. Lord, on the other hand, my lord, in Minerva Mills, Lord, an interesting point, my lord, that the Sikh Industries Act, which was challenged there, was actually an act which took effect prior to the amendment to 31C. But yet 31C was struck down, Lord, on the anvil of 14, 19, and 21. And Lord, I think that is what is referred to broadly also in this. Now, my lord, the judgment in IR Collier. And I've put here, my lord, actually, my lord, what the question was and the facts to allow us to actually understand what was decided. The matter was duly referred to a bench of 9 judges. The judgment is reported in so and so. The challenge before this High Court was that the Gudalur Jannam estate abolition and conversion into Rayatwari Acts 1969, insofar as it vested forest lands in the Jannan estates in the state of Tamil Nadu, was struck down by this court in the Balmadis Plantation Limited because this was not found to be a measure of agrarian reform protected by 31A of the Constitution. Section 2C of the West Bengal Land Holding Revenue Act 79 was struck down by the Calcutta High Court as being arbitrary and therefore unconstitutional, and the special leave petition filed against the judgment of the state of West Bengal was dismissed. By the Constitution, 34th Amendment Act the Janvam Act in its entirety was inserted in the 9th schedule by the Constitution 66th Amendment Act. The West Bengal Landholding Revenue Act in its entirety was inserted in the 9th schedule. These insertions were the subject matter of challenge before the 5-judge bench. So one of the very troublesome aspect of the 9th schedule was that after a court had set aside a statute, despite the constitutional basis of it being set aside, not being altered by Parliament, they could simply validate it by putting it into the 9th schedule. Well, that has been long the criticism of the 9th schedule. But the contention urged before the Constitution bench was that the statutes inclusive of the portion thereof which had been struck down could not have been validly inserted into the 9th schedule. That judgment, now the question, you'll also will immediately notice a slightly different question from the question referred. Well, the fundamental question, or as my lady pointed out, but on and after 24th April 73, whether the basic structure document was propounded, it is permissible for Parliament under Article 31B to immunize legislation from fundamental rights by inserting them into the 9th schedule. And if so, what is the effect on the power of judicial review of the court? So the question frame, not against me, on the 31C point, is that it was squarely a 31B question, which was framed. But Lord, please see now how it was answered. Now, I take a lordship straight to the conclusions, my Lord, longish judgment, 150 odd paragraphs. In conclusion, we hold that a law that abrogates or abridges rights guaranteed by Part 3 of the Constitution may violate the basic structure doctrine or it may not. So, Lord, not every part of Part 3 is a part of the basic structure. But a classic example, what I've often puzzled about is 18, my Lord, titles. Lord, it seems to be an odd inclusion in Chapter 3, but it seems to be strange to say that it is an inalienable human right, etc. So, Lord, they've noticed that. They've said not every part of Chapter 3 is actually entrenched. If the former is the consequence of law, whether by amendment of any article of Part 3 or by an insertion in the 9th schedule, such law will have to be invalidated in the exercise of judicial review power of the court. The validity or invalidity would be tested on the principles laid down in this judgment. The majority judgment in Keshavananda Bharati, read with Indira Gandhi's case, requires the validity of each new constitutional amendment to be judged on its own merits. The actual effect and impact of the law on the rights guaranteed under Part 3 has to be taken into account for determining whether or not it destroys the basic structure. The impact test would determine the validity of the charge. Now, the impact test is viewed what's called interchangeably the rights test or the impact test. But Roman 3, all amendments made to the Constitution after 24th April 73, the date of Keshavananda Bharati, by which the 9th schedule is amended by inclusion of various laws therein, shall have to be tested on the touchstone of basic and essential features of the Constitution, as reflected in Article 21, read with 14, 19, and the principles underlying them. To put it differently, even though an act is put in the 9th schedule by a constitutional amendment, its provisions would be open to attack on the ground that they destroy or damage the basic structure of if the fundamental rights or the rights taken away or abrogated pertain to the basic structure. Justification for conferring protection, not blanket protection, on the laws included in the 9th schedule by constitutional amendment shall be a matter of constitutional adjudication by examining the nature and extent of infraction of a fundamental right by a statute sought to be constitutionally protected, and on the touchstone of basic structure doctrine as referred to in Article 21, read with 14 and 19, by application of the rights test. Now, here comes the second test, and the essence of right test, taking a synoptic view of articles in Part 3 as held in Indira Gandhi's case. Applying the above test to the 9th schedule laws, if the infraction affects the basic structure, then such laws will not get protection of the 9th schedule. This is our answer to the question referred to us, Vide Order 14999 in IR Kolio and State of Tamil Nadu. So, Lord, so far, Lord, it would be difficult to say that this is a 31C judgment. This is very much a 31B judgment. I fully appreciate that. Lord, 5, if the validity of any 9th schedule law it has already been upheld by this court, I'm so sorry, small error, it would not be open to challenge such law again on principles declared by this judgment. But that was the pernicious effect of 31B. But however, if a law held to be violative of any rights in Part 3 is subsequently incorporated in the 9th schedule after 24th April 73, such a violation infraction shall be open to challenge on the ground that it destroys or damages the basic structure. As indicated in Article 21, read with Article 14 and 19, and the principles underlying thereunder, action taken and transaction finalized as a result of the impugned acts shall not be open to challenge. Now, my lord, some of the salient features are set out here. My lord, before I go to the salient features, my lord, your lordship knows enough of the judgment. But just to take a view, I'll take your lordship to my submissions on this and come back. But the salient features, my lord, I must confess to plagiarism, my lord. I've taken them from my learned friend, Mr. Devarajan's note, which he had kindly shared with me, my lord. My lord, he had done such a masterly job of it, my lord, I saw no reason to alter it in any way. But may I take your lordship, my lord, straight now, my lord, to the conclusions that I have drawn in paragraph 9. But I'll come back if necessary to the salient features. But more broadly speaking, what the judgment does is that it broadens the defense that is given by fundamental rights. Lord, it is said it is no longer an isolated pools. It should be viewed as the principal controlling influence over the amending power. So, Lord, that is the broad thrust of what this does. But there are certain observations with regard to 31C I'll come to. Now, Lord, the conclusions I have drawn, Lord, are these. But the conclusions that can be drawn from the judgment in IR Colio as stated below. When a law abrogates or abridges rights granted by Part 3 of the Constitution, it may or may not violate the basic structure doctrine. The test to be applied is either the rights test or the essence of rights test. The rights test is as under. First, the court must test whether there is a violation of Part 3. And second, if such a violation is found, its impact must be examined in terms of its effect and substance to see whether it destroys the basic structure of the Constitution. In the event it does, then I quote, invalidation has to follow. The essence of right test is explained in M. Nagaraj's case. Within Part 3, 14, 15, 19, 20, and 21, your lordship noticed that this was not recognized in the conclusion, but it is in the body of the judgment, are recognized as a part of the basic structure. The validity of 31A and 31C were not questioned and accordingly expressly held to be valid. Now, Lord, this is the interesting observation. Despite the denial of Article 14, and on the basis that these articles have indicia, which is not there in Article 31B. Now, my lord, some observations on the impact on the present case. And Lord, your lordship will take all of this in the spirit that, my lord, I accept what your lordship say, and Lord, it may or may not be decided by your lordships. Lord, applying the essence of rights test, Lord, essence of rights test, my lord, slightly different from the rights test. Lord, summarized to mean that we must go behind the principles with each of the fundamental rights. Lord, I had thought, Lord, that a reference to essence would be a narrowing down of the right, but actually it is a broadening of the right. What it says is that we must go by the principle of the right. So we must read the Constitution as a whole for that. So Article 14 should not be read, for example, in a formalistic manner, or we must read it in a broad manner in accordance with the spirit of Article 14. Applying the essence of right test since 21, read with 14 and 19, the principles underlying them have been held to be a part of the basic structure. Article 31C, insofar as it is inconsistent with or abridges rights under Article 14, destroys the basic structure. Even applying the rights test, the same result follows. Accordingly, the consequence, now, my lord, is that invalidation of 31C has to follow. Now, my lord, this is controversial, I see that. But let me set out my thought process for your lordship. There was no challenge to 31C in IR Colio. The statement with regard to 31A and 31C and the fact that they differ from 31B should be understood in that context. In the present case, the question of 31C squarely arises, and other things being equal, but what I mean is if you exclude Keshav Nanda, etc., and subject to what is stated below, it is open to this Honorable Court of 9 judges to examine the validity of 31C. This is especially so as Colio has observed that 31C results in a denial of Article 14. The determination of the validity of 31C in Keshav Nanda Bharti is, however, binding. 31C was upheld by a majority of 7 judges, 6 judges, Chief Justice Ray, Palekar Dwivedi, Matthew Beg, and Justice Chandrachud, as he was then, held that it should be upheld because of the amending power of Parliament was absolute and unlimited. Justice Khanna, even on the basis of the limited power to amend, upheld the validity of Article 31C. In this regard, see Justice Bhagwati in Minerva Wills. But he has done a masterful analysis of this aspect. The impact of the judgment of Colio is, however, to render 31C without any force. the validity of 31C, while binding, is a matter of precedent, is depleted of purpose. Now, my lord, there's some follow-up also, my lord, which is there. Follow-up all concerns the test, but if your lordships are not going into it, or it may not be very relevant. So, my lord, this is the issue with regard to Coelho. My lord, with the greatest of respect, my lord, to say that these deeply.
Thank you, Mr. Thank you, Mr.
Deeply obliged.
Yes, Mr. Devraj. Now, you are going to be arguing the 39B point basically.
Well, they have noticed the reasons. Obliged. Sinfully not.
See that.
But didn't I say that?
With your Lordship's kind permission, that's. Well, before I attempt to interpret 39B, I would request your Lordship to have a look at section, Article 39. Right. The state shall in particular direct its policy. My lords, our case is that if it's a policy of the state, it can't be restricted to a few wards in a municipal corporation. That's our first case. Our first point is on the question of policy.
That may be a ground to challenge the act.
The act is under challenge, my lords.
That is before the bench which will hear the challenge to
So
the
I go before your lordships, but when it comes to an interpretation, my lords, one point that your lordships have repeatedly been saying that if we feel that it's an academic question, we will not decide it. The point I'm trying to make here is twofold. One, before we go to question whether private properties would be material resources of the community or not, the question that we need to consider is what is material resources, one, and two, in respect of the matters before your lordship, is there a material resource? I only bow to what my Lord the Chief Justice said. We are not entitled to the property. We are on whether it's a resource of the community. My lords, again, the question here is not just resource of the community. Is it a material resource of the community? I'm emphasizing the words here, my lord. I'm on policy and I'm on material resource. Before I come to the question whether private can be included or not, this question might kindly be considered.
Must also bear in mind,
Please.
material resources of the community is in the context of distribution.
I bow before your lady. I bow before your ladyship's suggestions, my lady, because our case further, when we go through, I will take the liberty of taking your lordship through the act. Only that's chapter 8A, because that might clarify quite a few points. Is there a distribution of control? Is there a distribution of material resources? Now, material resources, once I can zero down and say that material resource should be a cut resource which produces goods or services for the community. If it does not produce goods or services, it would not fall within the category of material resources. That is my humble submission for your lordship's kind consideration. Here, my ladies, what is the situation? The situation is that a cess was levied on these landlords and tenants for carrying out structural repairs. The state says it is our duty to carry out structural repairs. When I say state, my lord, I refer to the board. If they don't carry out structural repairs, they don't give me the wherewithal to carry out repairs. My rent is frozen at 1940 levels. The cost of all building materials, construction materials are shot up, and I'm not put in a position to carry out repairs. Would such buildings form a material resource, much less that of the community? This is a question which I would try to satisfy your lordships, that this is not a material resource, much less of the community. That's the first.
Clause B has 4 aspects. The primary aspect is material resources of the community. What is it dealing with? It is dealing with the distribution of the material resources of the community. What facet of distribution is it dealing with? It is dealing with ownership
And control.
and control. Because are so distributed qualifies ownership and control.
Correct.
Ownership and control of what? Of the material resources.
And for what purpose?
Distribution of what? Distribution of the ownership and control of the material.
Material resource. Now we are.
Now, what is the object? To subserve the common good. And the fact that the legislature, that the constitution uses the expression ownership and control is very significant. Ownership refers to the title or the vesting of the title. Control is much broader in its understanding because it's not confined to title.
Here, my lords, I'm raising 2 issues for your lordship's kind consideration. The first, as I already indicated, my lords, when the Constitution says that the state policy of the directly its policy, now would it be only for the city of Bombay? Would it be only for the district of Nasik, or should it be that policy should be over the state? This is the primary question.
That wouldn't worry us because then the state can always make an under-inclusive classification.
Yes.
Then you say that, look, the condition of the buildings in Mumbai is so unique that you don't have to legislate, you don't have to regulate the entirety of the state. That the state can easily, that is not an issue at all.
My lords, if it were a regulation, my lords, I would have bowed to your lordship's suggestions immediately. But here it's not a regulation, my lords. Here it's not a regulation.
So, we are not so much today interpreting the provisions of the statute as we are interpreting the expressions of clause B of Article 39.
I go to what my lord the Chief Justice has said, but I request my lord the Chief Justice to kindly consider whether we could interpret this, dehouse the facts before us. Because this question has come to your lordships on the basis of certain facts which were there.
but when we are interpreting Article 39B, we don't interpret it in the context of that statute today before the bench of 9 judges.
I would request your lordships to kindly consider it.
There is a dichotomy between privately held property and publicly. For instance, will 39B cover only those lands which are what you call in Maharashtra Gairan lands or the grazing lands? Or would it also cover in certain cases private
Only
property?
one interjection with so that your lordship's discussion can also be suitably, resources, psychologically because of MHADA and Rent Act, we are considering land and building. The resources would mean several mines, minerals, airwaves, etc. Several things.
Natural resources as well as man-made resources.
Yes, exactly. No, not just land or buildings. That also may be one of the focus of examination.
My lord, I have no difficulty in the term resources. I have difficulty in submitting to your lordships that my building would be a material resource. Because your lordships have time and again held. Sorry.
What are these about?
So Devarajan is that, look, the MHADA Act contains a declaration that it is intended to give effect to the directive principle contained in 39B. Your contention, I mean, we are just trying to understand your argument. Your argument is that, look, you could not have made that declaration because 39B cannot by any standard extend to private property. I think that's your,
No, my lord, my submission is slightly wider than that. What your lordship says is one part of what I'm submitting. My second part of it is, before you could make such a declaration, because your lordship and Keshavananda said this is justifiable.
make the declaration.
Before you make a declaration, you must come to the conclusion that it's a material resource.
Obviously.
I'm on that. I am trying to make a submission.
According to this can't be material resource.
According to me, it can't be a material resources. Old dilapidated buildings cannot be material resource of the community. This is my submission.
Questioning the declaration itself.
In a way, my lady, in a way, I'm trying to interpret 39B to say that before 39B can apply and the subsequent things can follow. Yes, what I interpreted, as my ladyship said, I need to go through the act to interpret the rest of 39B.
But why can't?
But I'm not going there.
Why can't it be interpreted like this, that any building, old, we are not dealing with a building. Buildings which are in the occupation, old dilapidated buildings in, say, like the island city, which are in the occupation of a large mass of occupiers and tenants. They constitute a part of the material resources of the community because ultimately it's a source of habitation and abode for such a large group of citizens.
My Lord the Chief Justice, I go to what your Lordship said, but my Lords have time and again said, made a distinction between a resource per se and material resources. This is where I would try to convince your lordships that yes, this is a resource, but is it a material resource?
Just one,
I'm sorry.
add to what the Chief Justice has asked you. The material resources of the community, when you look at that expression, are we not also looking at the community of inhabitants in a dilapidated building?
Please, madam.
Because if you look at their need, a building is crumbling down, a building is no more safe. So, community who are occupying that building, it is a material resource and a vital material resource for them.
Again, my Lord, I could not make my point clear.
No,
That it is a resource, the petitioners don't dispute. The question is it a material resource? Because your lordships have said, for a resource to be a material resource, it should provide goods and services for the community. What is my building doing so?
It provides a service. What is more fundamental than the right to housing? It provides a place of abode for such a large segment of the community. Take a building which has, say, 70 occupiers or 40 occupiers. It's a community, as Brother Rishikesh Roy says, that it's a community of occupiers.
Why the community will have to fight for this community?
Yeah, yeah, you just continue.
Please, my lords.
Check.
Mr. Devarajan, have you got your, have you made some written submissions?
I made a note, my lords, but that note I was not giving your lordships because quite a bit of it your lordships have already shot down. So I don't want to give it because those points I can't raise now. The lordships have already told us that we can't go into that. So I don't want to give that to your lordships. Why say?
So what are your formulations? Because
Now, my lord, my formulations are like this, my lord.
your submissions on Article 39B.
Yes, I would start, my lords, by saying, lordships permit me, I would like to read certain passages from Krishna's judgment first.
In Justice Krishna's judgment in that
In that Ranganath Reddy's case, because that should give us a, that will give us a background.
Where is Ranganath Reddy's, where is it?
What's the page mein hai?
It's volume number 5.
Starts from page 1717.
Page 1727 PDF.
Give the proposition. When the proposition is read.
Yeah. My lords, as my learned friend rightly said, let me just put the broad proposition before your lordships, before I take your lordships to Ranganath Reddy.
Yeah.
My lords, the way that part 4 has been drafted or prepared, part 4 is of the nature of instructions to be given to the state. In that context, we'd have to read 39B also. We can't, I do not want to read 39B, dehorse the context. First part. The second part is, my lords, without taking tutor, when I read 39B also, I can't interpolate or leave out certain parts of 39B. That's the interpretation. When I come to interpreting 39B, my proposition is I read 39B as it is without adding anything into it or without removing anything from it, because this is something which is going to affect the citizen's right to a non-justiciable provision. So therefore, these two concepts, my lord, kindly consider as being the basis of my further submissions on this point. But before I take a lordships there, I thought that if I could highlight to your lordships the background in which Justice Krishna Iyer made the statement and what was the thought process of my Lord Justice Krishna Iyer when he made the statement, it might help me to explain to your lordships a little better what I'm trying to project.
Right.
So my lords may kindly go down to, before I take your lordship to Justice Krishna Iyer's judgment, I won't take you long because that's already been cited, some passages have already been cited from the majority judgment. Justice Muntralia's judgment has already been placed. Yeah, Karna. Don't know. You go to Justice Krishna Iyer, that passage which I told you, don't beach mein mat haath lagao. Sorry, my lords, I'm not very conversant with this. Hard copies I would have easily managed. The point I'm trying to say, my lords, Justice
Krishna's judgment?
My lords, may please see para 81
Starts at 40.
of Justice Krishna Iyer's.
Starts at 40. Page 177.
Yeah. Yeah.
57.
Okay.
Can give us the page number.
Yeah. My lord, may please, Krishna Iyer's judgment is at page 1750, my lords, of the
1750.
1750, volume 5. I mean, the relevant portion of Ranganath Reddy models.
What's para 81 at page 17?
1750, para 40, lordship may permit me to read from para 40. I know it's a little longer, but I'll try to cut short and put whatever I think would be required by us.
Better read para 40 first.
Yeah, please, my lords.
Before the preface.
Yes, my lords. We go wholly with our learned brother Untwalia J. Then why a separate afterword? Please ask this question. Because to put it simplistically, sorry. Sorry, my lords.
Yes.
Please, my lords. Because to put it simplicity, a legislation for the nationalization of contract carriages by the Karnataka state, where provision has been made for fair compensation under present circumstances, has still been struck down by the High Court on the surprising grounds of absence of public purpose, elusiveness of compensation, state takeover being beyond the orbit of Article 39B and the like, and to express ourselves emphatically in reversal on the obvious yet basic issue we itemized below, which is necessary to obviate constitutional derailment again. The public sector in our constitutional system is so strategic a tool in the national plan for transformation from stark poverty to social justice. My lords may permit me to pause here for a moment. The background which my lord seems to have is nationalization. His whole focus was, when I nationalize, I can take private property and nationalize it. That seems to be the focus. It is in this context that the phrase has been used there. This is my humble submission, my lords. I can't leave out what Justice Krishna has said, dehorse what was in his mind. So, my lords may permit me to go further. My lords may please see para 41. If the state to subserve the objects of governmental or other like agencies compulsorily takes movable property or reality of private citizens, the like of which are readily available in the open market, does the law authorizing such violate the limitation of public purpose imposed by Article 31(2) of the Constitution? Today, my lords, I can't go further on because I don't have Article 31(2) on my statute today. But yet, the underlying principle seems to be nationalization, as I pointed out earlier. Throughout, even in this paragraph, my lord, the lordship is concerned with nationalization. It is in that context, again I re-emphasize, my lord, it is in that context that that phrase finds place in Justice Krishna's judgment. Not that 39B, not that in 39B private property would be included. No, he says you take private property for nationalization. There in that context, it says distribution of such property would be for the common good because I'm giving it to the public at large. I'm taking from one person and giving to the public at large. It is not a case where a private property will be taken and given to another private person. That is not what he had in mind. My Lord Justice Krishna had nationalization only in mind when he made this submission. This is my humble submission for your Lordship's kind consideration. I'll take my Lordship still further. Where my Lord deals with distribution also. My Lord says distributed. There also my Lord says that is the basis of 39B. Distribution for the common good again means nationalize and give it to the people. Don't keep it with you. Give it to the people. Throughout, give it to the people. That is his whole focus. With this background in mind, my lords, I may kindly be permitted to now read the provisions of Article 39. But before I go to 39, a few other articles which might throw some light on the interpretational process.
Mr. Devarajan.
Yes, sir.
Perhaps you will also take us on the objective of the Act, because after all, we'll have to consider, together with what you are trying to canvass before us, that it is only in the context of nationalization, because the Act obviously doesn't think of nationalization, but it talks about giving it back to a community or a let us say, cooperative society. So therefore, you'll have to take us through the objective of the Act as well.
This Nationalization Act or our Act?
The MADA Act.
MADA Act. Please, my lords. I was avoiding it, my lords, because in between it came from your lordship that the lordships would prefer to deal with this.
Don't get derailed.
Sorry.
We'll have to understand the context of the Act.
Yes.
Please, my lords. I will, with your lordship's kind permission, I'll take your lordships through the provisions of the statute also. But what is its purpose? I may tell your lordships in brief. The purpose of Chapter 8A of the Act is preservation of inverted commas. I'll set out those provisions because I've got a note which I'll hand over. Each section I have analyzed, I'll put it. Before that, my lords may kindly permit me to just clear this small aspect which was there in my mind, which I thought I would share with your lordships, and namely about material resources. I don't want to go into material resources per se. I already made a submission to your lordships that I have to read 39 in the context in which it was placed in the statute book. And the context is what? The context is, it's a directive principle to the state. To do what? 37 very clearly says, shall be the duty of the state to apply these principles in making laws. And now in that context, when I come to 39B, well, let's have 39B for a moment, please. Thank you. Thank you. Well, let's would your lordships have 39B for a moment, please?
Yes.
Yes. My lords, my submission here is, if the term material resources of the community is to include private property, if it is to include private property, then some words have to be added, or some words have to be deleted. Namely, here, my lords, the ownership and control of private material resources of the community are so distributed. Private has to be added there, or what they should remove is material resources are so distributed of the community has to be removed. If it is removed, then this material resource will apply to all resources, private and public. We are asking ourselves to read this article, which has got drastic consequences of shutting out my constitutional rights under Article 14 and 19 in a manner which is not present in that article.
The term community, it will not be included.
Community is not defined, but I take it that community means the entire, whoever is, what should I say, affected by, or a particular, like we say, the Tamilian community, the Andhra community.
Private also. Community means it's a generic term basically.
Correct. But when I talk of the resources, I'm now talking of the resources also. And here, my lords, sorry, my lords is saying something.
Of the community.
Bharat cooking.
Are you trying to say that resources of the community, material resources of the community does not encompass private resources?
This is what I am trying to submit, my lady. For the reason that if it were so, it would read private material resources of the community also. Because as my lordship said, every individual is a member of the community. There's no doubt about it.
Talks about resources of the community only.
As that's this point I'm trying to say, trying to canvass for your lordship's kind consideration is, if it was intended to cover private resources, the 39B could have specified it. Rather than leave it for an interpretation to somebody who could misinterpret it or interpret it in a different way. It's just an addition of a single word or deletion of certain words. Here, my lords, I will take your lordships through one judgment, which I could lay my hands on, where the term material resources has been considered. Apart from their lordships have said.
For a cooking relevant portion 231.
Okay. In that judgment compilation, what was that, volume 5?
Yeah, volume 5.
Volume 5, my lords could have page 2314 for a moment, my lords.
1983, 1 ICC 147. Page 2.
Okay. Troubled my lordships to have a look at that judgment, please.
Yes.
My lords, in Sanjeev Coke, though it's against me on other aspects, my lords, one very important factor was considered.
But in Justice Krishna's judgment, just read para 80 and 81.
Please.
Justice Krishna links it with the whole concept of redistribution.
Correct.
And says that the focus of Article 39B is on redistribution. Then whether that material resource is public or private should not make any difference. That's the logic of his judgment.
Essentially, my lord, that is nationalization concept, my lord. If I read this again in the
Para 80 and 81, you can read.
Yeah.
1771.
Yeah, my lord, sir, 1771.
17,
1770, 1771.
Right.
Yeah, please, my lords. My lords, reading para 81, my lords. My lords, could I read para 81, please?
Sorry?
Could I read para 81 onwards, my lords?
You can actually read para 80 as well.
Please, my lords. This takes us to the non-negotiable minimum of nexus between the purpose of acquisition and Article 39B. 39C was feebly mentioned in Article 39B, was forcefully pressed by the appellant. Better read 39B before discussing the full import. Certain principles of policy to be followed by the state. The state shall in particular direct its policy towards securing that the ownership and control of the material resources of the community are so distributed as best to subserve the common good. The key word is distribute, and the genius of the article, if we may say so, cannot but be given full play as it fulfills the basic purpose of restructuring the economic order. Each word in this article has a strategic role and the whole article a social mission. It embraces the entire material resources of the community. Its task is to distribute such resources. Its goal is to undertake distribution as best to subserve the common good. It reorganizes such distribution, by such distribution, the ownership and control. Resources is a sweeping expression and covers not only cash resources, but in availability to borrow credit resources. Its meaning given in black, so my lords go through it. Now, just take your lordship next. And materials of the community in the context of reordering the national economy embraces all the national wealth. My lordships, Justice Krishna here would like to even take away my salary or my fees and distribute it. I'm not saying anything about anybody else, but at least for myself, I can say, if what Justice Krishna says here is implemented, whatever fees I earned also can be taken away and distributed.
They do that in tax.
They did it in the past, my lords.
97% was the tax at one time.
They did it in the past, my lords. They say you earn 3,000 rupees. If you earn 3,000 rupees, if your DA goes up by 1,800 rupees, we'll reduce your salary and keep it 3,000 rupees. They did it in the past, my lords. So all the time trying to suggest, my lords, again, reading this para, my lords, it takes me back to the same principle. The same principle he wants to usher in a socialistic pattern of society.
One of the aims of that is with regard to concentration of wealth in the hands of a few. So in that context, nationalization was one of the vehicles to see that such a thing did not happen in society.
So, my
distribution of wealth.
My lady, taking what you file from my ladyship's a little further, would taking away from one person fall within that category? Would taking away a private person's property fall within that category? Is a question I am asking myself, my lady.
All agreement, the form is based on.
I'm not taking my lordship through para 82 because he categorically deals with nationalism and says it has a nexus with distribution. I have no issue. I'm not going into that.
This is not nationalism.
Now, since my lords would like me to take your lordship through the act in question, where protection of 31C is sought by the state and which we feel they cannot have, I will broadly tell your lordships what that chapter is. Broadly, I'll tell your lordships.
81 also.
Sorry, para 81. Please, my lords. My lord has got it. It's at page 1771 of the compilation. Resources is a sweeping expression and covers not only cash resources, but even ability to borrow. And material resources of the community in the context of reordering the national economy embraces all the national wealth, not merely natural resources, all the private and public resources of meeting material needs, not merely public possessions. Everything of a value or use in the material world is material resource, and the individual being a member of the community, his resources are part of those of the community. No. Should be bad cooking. Yeah. This is a constitution member.
So land. Land. Any land in excess of the ceiling that was taken away, it vested with the state for the purpose of redistribution.
Yes,
That is private land.
true. True. My lady was taken away under what provision of the act? Under what provisions? And in respect of what?
Land Reforms Act.
Correct. Land Reforms Act, my lady, we have specific provision, Article 31A, which deals with estates. There they don't rely on 39B at all. They don't rely on 39B at all. What falls from your leadership, yes, I did think about it, but then they don't. They don't say, I pass an act and seek protection elsewhere. 39A itself says, if it's an estate, yes, I can take it away. Because the whole concept of 13A is zamindar system to abolish zamindar system. Large tracts of land, they wanted to give it to the tiller. Land to the tiller was a concept those days. Today they are saying land to the tenant. Even if the landlord has got a single building, even if he's surviving with a meager rent, you take it away from him. Today, my lady, my kindly let me, what Justice Krishna has said about material resources, a subsequent bench has clarified what material resources. Give me Bharat cooking. This is the string. Constitution bench in Sanjeev Cook. That judgment is against me so far as 31C is concerned. My lord.
Sanjeev Coke now?
Yes, Sanjeev Cook, Manufacturing Company, 1983, 1 SCC 147. My lord, it's at page 2294 of this case law compilation. It starts from there.
22. And portion is 2314.
Yes. The relevant portion is para 19 at 2314, my lords. Sorry, the judgment starts where? My lord, the judgment starts.
2313.
Huh? Sorry, my lord.
19 is 2313.
Yeah, but relevant portion is yeah.
It's, my lord, it's para 19, but the relevant portion is on the next page, my lords. 2313 is where it starts. 2314 is the relevant portion, my lords. May permit me to read it, my lords. The expression material, I'm sorry.
Where you are?
My lords, after the starting of the page, the lordships are dealing with state of Karnataka with Rangnath Reddy on the top. And about say 8 lines below, my lord. It's 8 lines below.
Is it part of paragraph 19?
Yes.
Yes, my lord. Paragraph 19, part of paragraph 19. my lord. Unfortunately, I don't see the placitums here, which were there in the past.
Please send.
Yeah.
Send.
The third line, read from the third line.
Yes.
Please send.
She said urged that if the word distribute was given its proper emphasis, it would inevitably follow that material resources must belong to the community as a whole. That is to say, to the state or the public before they could be distributed as best to subserve the common good. Since these material resources which belong to the state only could be distributed to the state, Sri Sen argued that material resources had first to be acquired by the state before they could be distributed. A law providing for acquisition was not a law for distribution. Now, this is important, my lords, where they say, we are unable to appreciate the substance of Sri Sen. The expression material resources of the community, now they have defined this, my lords, of the community means all things which are capable of producing wealth for the community, not that all things in which the community has an interest. No, they say that must produce wealth for the community. Then it will be a material resource of the community. Here, so this is the test, my lords. Is this a material resource or not? The test is, would that resource produce wealth for the community? Not for myself. This is the test that your lordships have laid down. And then they say, there's no warrant for interpreting the expression in so narrow fashion as suggested by Sri Sir. I'm not going further, my lord. For my limited purpose, my lords, material resource means it must produce wealth for the community. Like the buses did. In a nationalized program, those buses did. Whether they actually earned or not is a different matter, but that was the intention. So, yeah, I finished this 30 now.
B refers to material resources of the community, does not refer only to resources owned by the community as a whole, but it also refers to resources owned by individual members of the community. That's what they say at page 2315.
Please, my lords. No, this is the point that I am trying to say.
Resources of the community do not mean public resources, but only, but include private resources as well.
The point that I'm just emphasizing a little more, yes, private resources, but for what purpose? Producing goods and services for the community. If I have a piece of land which is just lying there, you take it and produce goods and services for the community. There's no difficulty in 39B applying there. The crucial word, according to me, is that, my lords, this is emphasized by the interpretation of 39B. So since, my lords, it will be necessary for us to see what this chapter 8A is about, my lords may permit me to just place it, my lords. Give me the act. Give me the act. No, give me the act. Broadly indicate, my lords.
Page 398.
My lords, where I won't want this side. This is what that Sorry, my lords. Keep it close. My lords, I had circulated one note which reads history regarding repairs. Could I take a lordship through that note, my lord?
Yes, certainly. Where is that?
You can't, okay, please. My instructions are, it was mailed to your lordship this morning, my lords.
Yes, we uploaded for us.
Serial number 6 at least. It's open. Number 6.
Okay. Actually, we should go to the act. More than the note. We'll look at your note, but let's look at the provisions of the act.
Please, my lord.
Of chapter 8A.
Yes.
And because they will give us a flavor of whether these provisions have a nexus of the distribution of the resources of the community for the common good.
Please, my lords, I will do that. Mera note on 30. My lords, the reason why I suggested this is, in this note, my lords, if your lordship kindly go to a little down, I have set out the salient provisions of the Act, my lords. At 12, my lords. At item 12.
Mr. Devarajan is the only councillor now who has to argue on this side.
My lord, small request, my lord. My learned friend might add a few things to what I have said, my lords. Few things he might like to add, and my learned friend Jal also might like to add a few things. Just a few things.
So, Mr. Devarajan, you can wrap up by 3:30, about 50 minutes.
I'll try to wrap up as fast as possible, my lords.
By 4 o'clock, we'll complete this side.
I'll try.
Tomorrow we'll
My
start
lords
with the
may kindly give me a leeway of about 10-15 minutes, given my speed is not that good.
No problem. But by 3, that's why instead of 3:59.
I will try, my lords. I will definitely try to obey your lordship's directions.
4 o'clock, then we call upon the other side tomorrow.
Okay. My lords, if your lordships, just to shorten the things, in this note, my lord, serial number 12. In this note, serial number 12, I've set out a salient factors of chapter 8A. But I need to take your lordship through the whereas clauses also, which I would do subsequently. But now let me take your lordship to chapter 8A, because this will directly answer the question that has been posed to me. My case is, my lords, that chapter 8A, in its pith and substance, is for preservation of housing stock. These old buildings, how do I preserve them?
Not just preserve them, but actually reconstruct them as well.
So that's why I will take your lordship through the section 103B. It will become very clear. They use the word better preservation or reconstruction. The emphasis first on better preservation, my lords. But my lords may permit me to just take a lordship briefly through this note, and then I'll take a lordship through the sections.
Which is the chapter?
Chapter 8A.
What is the page, the PDF page?
Chapter 8 is 4033 of the main statute.
No, we have
4033.
7 of the new compilation.
My lord, my lord, we put the gazetted copy today.
We've got chapter 7A now.
8A.
And 4033. We'll go to chapter 8A.
8A, my lords.
7A is not in question here.
Actually, my lords, there was no 7A at all.
That's a typo.
There was a typo, my lords.
In the SEC.
Absolute typo, my lords.
3A is in chapter 8 or
8A, my lords. If you, my lordship may kindly see,
Their
today's
concentration is on 8A. Chapter 8A is the,
PDF page. We're just trying to.
4033
Yes,
is 8A.
So 103A is in chapter 8A.
please start from there.
Because the title says chapter 7A. That's why I asked. It's a typographical.
My lords, today we've uploaded a gazetted copy of the Act, my lords. In that, lordship will find it page 237, chapter 8A.
Typo.
I'm told it's a typo, my learned friend told me this.
it is 8A.
It's 8A actually.
4033 in which volume?
Volume 4.
Volume 4. Volume 4. No?
He's comfortable.
My lords, could I trouble your lordship to look at the gazetted copy, because there might be certain.
No, it will be the same. That only changes that chapter 7A.
No, as I said, I've not cross-verified, so I'm requesting.
You read the gazetted copy, if there's some change here, we'll know.
All right, my lords. My lords, please see section 103A first.
Yeah.
Section 103A. Okay. Section 103A states, my lords, that the chapter will apply to all buildings constructed prior to 1st September 1940. The proviso to that says two things. One, it says that the buildings should be predominantly residential. That is, more than 50% of the occupants must use it for residential purposes. That's the first point, my lords. The second point is, it should be a building belonging to category A. That is to say, other buildings are not part of chapter 8.
It's defined in section 84.
Chapter 8 is defined in chapter 8 under the heading first.
And it's category A is in section 84 at page 4023.
Correct, of chapter 8. Briefly put, my lords, the categorization was done like this, my lords. Buildings constructed prior to 1st September 1940 are category A. Buildings constructed from 1st September 80 till 31st December 1950 are category B. And buildings constructed from 1st January 1951 till the enactment of the Cess Act. There used to be a Cess Act before, my lords, called the Bombay Buildings Repair and Reconstruction Board Act, 1968. That till then, my lord, all those buildings were categorized as category C, and cess was being levied depending upon the category of building. That's in short, my lords. Here, my lords, may please see the first provision to section 103A. Provided that nothing in this chapter shall apply to any such building belonging to category A, if on the commencement of the MADA Second Amendment Act 1986, out of the total number of occupiers of such building, 50% or more occupiers are using the tenements or premises in that position for commercial or non-residential. In other words, my lord, even though cess could be levied on a category of building, these buildings, where it's predominantly commercial, would not fall within the provisions of Chapter 8A. Then we come to the explanation, my lords. We are today, for our present purpose, my lord, explanation is not that relevant. What is relevant is 103B. 103B says, notwithstanding anything contained in Chapter 8 or any other law, a cooperative society formed or proposed to be formed by under the provisions of the Cooperative Society Act, but not less than 70%. I would stop here for why I'm saying this 70%, my lords, is when I deal with 39B and the policy. When I deal with the policy in 39B, the policy of the state and 39B, what is the correlation between this act and the policy? If there is a policy, it should apply to everyone. We know this act is doing two things. It's not dealing with all pre-1940 buildings. That means to say it's not dealing with all dilapidated or old buildings which they consider to be dilapidated. It is only dealing with certain old buildings, whatever be their condition. That's the first part. The second point, as I said, is the trigger is 70% people wanting it. And what do they want? And why do they want it? They want it for one purpose. They say, my lords, may please see, they make an application, they make a written application requesting the board to move the state government to acquire the land. For what purpose? This is important, my lords. So go just a few also. They 4 lines below that section, my lords. In the interest of its better preservation, my lords have got that. In its better preservation or reconstruction, offer new building in lieu of the old one, and intimate their willingness to pay the amount of such acquisition as may be determined under the provisions chapter, and to carry out the necessary structural or other repairs or wherever necessary. My lords, may please see, the reconstruction is wherever necessary to reconstruct a new building. I ask myself this question, Is this not a provision which deals with preservation of housing stock? If it is for preservation of housing stock, how are they referring it to 39B? Because one of the tests that your lordship have time and again said, we will see whether there's a nexus between 39B and the enactment. Here, I ask myself this question.
It has an nexus with distribution because what happens is that instead in place of the ownership of the erstwhile owner, the property upon acquisition vests in a cooperative society. And that cooperative society represents the interests of all the occupiers. So as opposed to the property being concentrated in the hand of the owner, as a result of this acquisition, title is transferred to a cooperative society, provided 70% of the occupiers want to come together and form the society and express a willingness to pay the amount of the compensation for acquisition.
If what your lordship said was the act,
idea is for the better preservation of the building, or if repairs are required, repairs, or where reconstruction is required, reconstruction.
The small aspect which I'd request your lordship to consider is there a transfer of ownership at all? Is there a transfer of control at all? Section 103C will explain this. Section 103C will explain the concept of what am I giving the cooperative society? Am I transferring ownership to him? Am I giving control to him? 103C will explain.
Now just see before 103C,
yes,
subsection 2 of 103. 103A. This 103A, no? Yeah, B. On receipt of the application under subsection C, under subsection 1, the board shall, after due verification and scrutiny, approve the proposal if it considers that it is in the interest of the better preservation of the building or it is necessary for reconstruction of a new building, and shall direct the cooperative society, whether registered or proposed,
to pay the
deposit with the board within a period specified by it in that behalf 30% of the approximate amount that would be required to be paid to the owner if the land is acquired, and give intimation that behalf.
My lord, in short,
put up front.
my lord, in short, that is the second part of our submission. In short, my lord, this act says, you pay the entire money of acquisition also, because 103B itself says so. You have to say that I will not only pay the cost of acquisition, but I'll also take care of the cost of repairs and reconstruction of any. If the entire money is to be paid by a private individual and the state does not have to shell out a single pipe from its coffer, would this be a concept of public purpose? And 39B has to be for public purpose, because every action of the state has to be in furtherance of public purpose. This is what your lordships have said time and again.
The public purpose really is the better preservation of dilapidated buildings.
Yes.
The reconstruction where reconstruction is necessary. Because reconstruction, in order to obviate a danger of collapse and a loss of
human lives.
And though the state does not pay the state carries out the entire acquisition. But since it's in the interest of the cooperative society, the amount has to be deposited by the cooperative society with the board.
They have to pay the entire cost, my lords. They have to pay the entire cost. They have to pay the entire cost. And way back, my lords, not today. In Kasturi's case, long ago.
Mr. Devarajan, we are not looking at the constitutional validity of the statutory provisions.
No, we are not. We are looking at it vis-a-vis 39B. No, my lords, I'm also making submissions vis-a-vis 39B, because to me, 39B has to be for a public purpose. Well, please, my lords, it has to be for a public purpose, and it is in public interest that 39B has been inserted. Sans that 39B would have no sanctity, my lords. A directive principle to a state has to have a public interest and a public purpose, my lords. 39B can't be read towards these things. This is something, my lord, my voice is a little loud, but I don't mean any disrespect to the bench. I don't mean it, my lords.
very frequent visitor to the Supreme Court.
My lord, I was practicing here till I reached a stage where I could not walk, my lord. Even today, I'm standing with great difficulty.
Oh, we are.
I got a hip bone replaced, my lords. I could not walk. I could not stand the winter. And so I had to migrate back to Bombay from where I started my life.
But decibels here are astounding. That's what I was going
I'm
to
sorry, my lords.
Decibels here are astounding of some of your colleagues in the bar.
Especially on miscellaneous days, my lord.
Even if some lawyers are appearing virtually and they are on a mute mode, we can hear them.
Sir, I could say the same about you also, sir. I've been hearing you frequently, sir. I'm sorry, no offense meant, sir. No offense meant. No offense meant. Sir, if I may continue, sir. So this act, we are not, sir, again, I'm saying, I'm on the question of control. We are not checking the validity of this act, only trying to explain what are its content, and we are going to see whether 39B can at all apply. We are not going to the validity of that because I got other challenges to challenge this provision. I'm not on that. I am saying concept of distribution of control. Who has got the control? If I see 103C, the control is with the board, not with the society. If that society is given, it has to use it after reconstruction or repair for the same purpose for which it was using before. So where is the distribution? Where did you transfer the control? Secondly, my lords, if by chance one of the members disposes it off, immediately, my lord, that transaction is void, and the board will have a right to take back the property. Where is the transfer of ownership? These are the questions that are falling from the provisions of this act, my lord. So when I test this act, either on the basis that there should be a transfer of ownership or control, I don't find a transfer of ownership or control.
Right?
Because
Ownership and control was transferred to the cooperative society.
my lords, one of the incidents of transfer of ownership would have the absolute right to the property. I don't have.
I mean to the cooperative society.
I don't have a right, my lord, because they say the moment I gift it, my lord, if I read section 103C, then the lordships would see how drastic that provision is. If that occupant gifts it, that gift is void. The property can be resumed. If the society uses this property other than what it was using before it was acquired, again they will resume. Where is the transfer of ownership then? If at every stage, whatever I do, you are going to have it, you have the absolute control over it.
After the land is transferred to the cooperative society.
Even then, my lords, that is what I'm trying to.
And subsection 7 of 103B says, subject to the provisions of subsection 6, the authority shall convey the land acquired under this section to the cooperative society of the occupiers thereof.
Exactly.
With its right, title and interest therein, and execute without undue delay the necessary documents. Therefore, title is transferred to the cooperative society.
Yes. There they say I will transfer the title. But now let me see what 103C says. Let's see what 103C says. The transfer of title is subject to the conditions contained in 103C. 103C starting point. It says, after the land is transferred to a cooperative society, my lords, please kindly allow me to place this a little more forcefully. He says, after the land is transferred to the cooperative society, under subsection 7 of section 103B, which my lord the Chief Justice just now mentioned, what happens? The society shall use the same for the purpose for which it was used before the acquisition.
You can make it in
So,
commercial.
clause on usage.
No, it's not a clause on usage. The idea is that if it was for.
My lord, if I am the owner,
Converted into a five-star hotel.
Commercial.
lordship,
Converted into a five-star hotel. The idea is to protect the occupier.
no. See, no, they are not even protecting the occupier. That's the unfortunate part of it. If they protect the occupier, my decibel levels would have been very, very low. They are not. They are saying that go further, my lord, see. And if no member or tenant of the cooperative society shall transfer his interest in any tenement by sale, gift, exchange, leave or license, assignment. What is this? I mean, I don't have any of the incidents of ownership. I can't even gift it. And yet, there is a transfer of ownership to me. If this is the law, my lords, then I have to go my head. I have nothing else to say on this. Okay. Okay, we'll take him to that podium. To sit.
At that. We all wish you a very happy birthday.
I say that the
my-
court is very kind if you want to sit
learned
and
solicitor was
argue that,
suggesting to me that I should sit.
If at any point of time you want to sit and argue, please feel free.
that's how, that's
My
right.
lord,
The
it will
court
make
is
me
always
feel
kind.
sicker than I really am. I walk with a walking stick. Today I said, no, I am not going to carry the walking stick. Let me walk without a stick.
Should not do that.
And that's all. Because I have 3 people to hold my hand. Why should I need a walking stick for that? No, sorry, jokes apart, my lord. Come back again. My lord, I'll come back again. So, my lord, 103C. C, subsection 2 is a little this thing. It says, save as otherwise expressly provided in this chapter, and notwithstanding anything contained in any law for the time being in force. You cannot do this. But see the embargo, man. The embargo in 103C2, and then sub 3, if a corporate surgery contravenes the provision subsection 1, out. It will go back.
But Mr. Devarajan, see, 103 itself says that it will be used for the same purpose for which it was used prior to this particular.
Correct. So therefore,
so far as the occupants are concerned, their occupancy right in that building, whichever way it comes up thereafter, is protected. So it is to protect the right of residents.
could I make a small submission here, my lords? These are all people who are protected by the rent control legislation. Nobody can touch them or turn them out except by filing a suit in the rent court. Most of them have been living, and as my learned friend pointed out, there are people who are claiming tenancy rights in the state, in the city of Bombay, and practicing here. I don't take anybody's name. They are paying peanuts, my lords, for the huge premises that they are staying. So therefore, my only submission here is their occupancy rights are sufficiently protected by the provisions of the Rent Control Act.
Eviction, ejectment, etc.
To just swiftly respond to what your lordship says. My lord, I'm saying it extempo. Sorry.
And the responsibility then
1960.
Lordship's kind permission, can I take a sip of water, please? Obliged, my lords.
So what is the next provision you want us to see, Mr. Devara?
Yeah, well, I just want to point out one more thing. For a long time, it was in my mind that what's wrong? If the landlord is unable to maintain the premises, then what's wrong in getting the tenants to do it? To this, my lords, I found two problems to that question. One is, there was a provision under the old Rent Act and probably even in this Act, my lord, that if the landlord is not, because earlier, the lordships would be aware, earlier the landlord could increase the rent after carrying out repairs. Even if he doesn't have money, he could borrow money and carry out repairs and the tenant would repay that amount in pieces. Then they came out with an amendment saying that if the landlord is unable to do it, you carry out the repairs. And then you deduct it from the rent that you have to pay to him. All this not having worked, in 1968, they come out with an act called the Repairs Board Act, the Bombay Repairs and Reconstruction Board Act 1968, where they said, this board will carry out the structural repairs, you pay a cess, a tax is levied for carrying out those repairs. Even that they did not do. And today, in 86, they come out and say, these buildings are not being looked after by you. They forget that they have taken the responsibility to carrying out the repairs. They forget that they are taking money from the people for carrying out the repairs. If they have not carried out the repairs, today, they say in this act, if it's a lordship should see, this act, they seek to now, we might have committed default, we might have frozen your rents at 1940 levels, we may not have made it possible for you to carry out repairs, yet buildings have gone bad, so we will take property from you. So, whether at all 39B envisages such a situation is a question which I request your lordship to kindly consider. I'm a tenant myself, my lords, but still I'm fighting for a landlord's just demand. That please don't deprive me of the property that my forefathers have brought into. And my lords would be aware that when the Cess Act came, there was a challenge done. And the report was recorded as to what is the status. This particular thing is for only seven wards in the Bombay. And they're all old buildings, no doubt. But what is the remedy? Is it taking it away? Why not create conditions to make them carry out the repairs? And if they don't, then you take it away. This is all I say. You do whatever you want, but please make it possible for them. You don't say that I will take it, I will carry out the repairs, you pay me the cess. And at the end of the day, you say that I could not do it, so you give me the money, give me the building to the tenants. So tenants are given an opportunity, they don't do it. Board says that they will carry out repairs, they charge the cess from the tenants as well as from me. And at the end of the day, the building is in a bad condition. Who is responsible for that? I ask myself this question. Rents, it is now recorded, my lord, that cost of building materials have gone up substantially since 1940. Astronomically, my rent is for. If anything in the world has remained stagnant and steady, it is the rent of these landlords. This is that's an argument for the Rent Act, my lord. I'm not on that. But I am on whether at all 39B envisages this. If 39B is supposed to do equitable distribution, where is the equity in this matter? This is the question I am asking myself, my lord. My lords, I would stretch, my time is coming to an end. I have lots more to say, but I'll request my learned friend to continue, my lords. My lords, can I be thankful to your lordships for their kindness?
Thank you, Mr. Yeah. Yes, Mr. Farid.
So I'll attempt to answer the questions that have come from the bench. And first, my lords, let me answer on the interpretation of Article 39B. And my lords, the moment we consider the place in which this article appears, the interpretation is quite evident. And in fact, the Ranganath Reddy judgment itself explains why they specifically said that we are not endorsing what Justice Krishna Iyer said. And let me just indicate why. 29B is one of the duties of the states. It's not one of the powers. And that's one of the answer to my lord's question. Does 29B, if my lords interprets it, Article 29B, Article 39B, my lords interprets it narrowly, does it impact the power of the state to acquire, say, the coal mines or land or other properties? Now, Ranganath Reddy itself answers, and therefore let me just put it in this manner. There are three different sets of provisions in the Constitution. First is Article 245 onwards, which are the legislative power of the state, which include the power to acquire land. And as Ranganath Reddy says, that seen with the concept of eminent domain, power to acquire land, etc., is all covered in the legislative power of the state. So therefore, whether 39B exists or not in the Constitution, the power to acquire land, give it away, etc., is all part of 245 onwards, the legislative powers of the government, the union and the state. Now, what are the principles that are to be followed? Again, Ranganath Reddy records that it must be a public purpose. So if suppose in that case, it was transport permits were acquired, fair compensation was given. The court said that certainly the state has the power to acquire transport permit. The only test is compensation, public purpose. If these two tests are met, we approve the act. There is no difficulty with the act. We don't have to touch 31C. The act is valid as it is. 39BC and are therefore irrelevant. And that's what the majority says in Ranganath Reddy. Now, therefore, we now come to the two parts, namely part 3 and part 4. What are these parts and how do you interpret? And what is the principle that my lords will consider while interpreting these provisions? Article 3 is a fetter on the power of the state. My lords are, of course, familiar. I'm not going to expound on that. Part 4 is a duty of the state, and therefore 37 onwards starts with what are your duties. First, it defines the state. Who is the state? What are their powers? What are their duties? Now, once my lords considers holistically the provisions of part 4, it would be evident that part 4, 39B, is a duty of the state to use material resources of the community for the benefit. Let me just read that. To subserve the common goods. Now, seen as a duty, the only meaning, my humble submission is, that you can ascribe to 39B is that when there is ownership and control of material resources of the community, community can be state, a body under the state like the MADA, the Panchayat and various other bodies, and those Panchayat etc. are also provided herein. You have a duty to use the goods or material resources of the community to subserve the common good. It's a duty of the state. So do not use the material resource of the community not to subserve the common good. It stands to reason. And therefore 39B is a very limited provision which requires the state to act in a manner to subserve the common good. And therefore our humble submission is that when you read and why the words of the community are used is very crucial in interpreting 39B, because otherwise it would have simply stated that material resources should be distributed to serve the common good. It doesn't say that. It says ownership and control of the material resource of the community. It must necessarily mean, in our humble submission, resources which are controlled by the state in some manner, which will serve the common good. And of course, we leave aside 31C for the moment. This is the only consistent interpretation that can be given to 39B. Therefore, we are on both paths. First, it should be, and then I'll come to the touch upon the act also. There should be ownership and control of material resources. I do not want to dispute that a house is a material resource, no difficulty with that. But therefore, is it a material resource of the community for the purposes of Article 39? In some other context, maybe, certainly. In a context, you may say that the housing is part of the community's assets, no difficulty. But when you are casting a duty on the state that use the resources of the community for common good, what are you trying to imply or mean is the submission that I'm seeking to make. And it can only mean goods controlled by state in some manner, directly, indirectly, etc. And that also follows, therefore, and therefore what Justice Krishna Iyer and Mr. Devarajan therefore was rightly pointing out, that if you construe it in this manner to say that 39B will also apply to private goods, then in fact, Justice Krishna Iyer does advocate is that please acquire private property and distribute it. That is too extreme a view in my humble submission. It's too extreme. It's a Marxist concept that you acquire everybody's land and give it to everybody else. That is not, in our humble submission, the intent of 39B. It cannot be interpreted in that manner. The duty being cast on the state is not that go and acquire everybody's private property and give it to everybody else. That's not, in our humble submission, what 39B is seeking to achieve.
One of the public purposes under the Land Acquisition Act,
Lordships,
to give to acquire land and give it to the persons who do not have a site.
Absolutely.
Those who are landless, in the sense to give them a house.
I am grateful, and therefore Ranganath Reddy says for that you don't need 31C, 31B, 31A, you don't need 39B and C. That is inherent in eminent domain doctrine, because you can acquire land only for public purpose. If you acquire land, you acquire a coal mine, you acquire an estate, a jamindari, give it to the tiller, that's your power under 245. Nobody can take it away. In fact,
According to material resources of the community must mean resources which are controlled by the state.
I am deeply obliged, and that is the only meaning.
Private property.
That only meaning that would make sense, because if you forget 31C, capital C for a moment, that's the only logical meaning that you can ascribe to 39B, which is the duty of the state. The duty of the state is use your resources for public good. It is not to say that you please go and acquire everybody's private property.
Purpose of 39B.
Lordship.
What if we read 39B like you want us to read?
Lordship.
Purpose of 39B.
Lordship, there is.
Purpose of 39B.
Lordship.
What is the purpose, if we understand?
Lordship.
To remove equality.
Lordship.
To have a fair, equal distribution.
Absolutely.
Even if 39B is not there,
Lordship.
or
Lordship.
we agree with the interpretation you want us to agree with.
Lordship.
It does not include private property.
Lordship.
How will you escape 39 clause, 38 clause 2? The state will still have power to do what it can under 39B.
Certainly. I have no difficulty. I am not at all suggesting for a moment.
But even see argument we don't.
Lordship, in fact, my lords, what my lords has raised is precisely the point I wish to raise. It is of seminal importance how my lords interprets 39B. Power, it's a duty. The power or duty under 39B must be exercised consistent with the rest of the constitution, including various restrictions on the powers of the state legislature or the central legislature. My lords, I have no quarrel, no difficulty that state can acquire any land for public purpose, use it for various. But 39B is not saying you shall go and acquire all private properties and redistribute it. That's not our constitution. That may be a Marxist constitution. Our constitution is you can acquire it. 300 capital A exists. 39B has to be read in accordance with 300A. If my property is taken, you must give me proper compensation. You cannot give me an illusory compensation. So 39B duty, please use it for common good, no difficulty. But you can't say I will take it from one party and give it to another private party. That's not the intent of 39B.
How is a cooperative society a private party?
I'll come to the Act itself in a minute because Act, there is Chapter 8 and Chapter 8A. In fact, 8A has come because of failure of the state. I'll just indicate that in a minute.
So if we don't accept
Lordship,
the interpretation of 39B, which has been placed by Justice Krishna in Ranganath Reddy's case,
Lordship.
that would not render the Act ipso facto unconstitutional.
No.
It's just that the Act would then have to withstand the scrutiny of Article 14 and 19.
I'm grateful. That is all I was trying to say. That the power to pass legislation is there. It must meet the rest of the parameters of the Constitution, 14, 19, 21, 300A, and there are other provisions that we are relying on. Now, only benefit was under 31C, you have an additional protection. 14, 19 are out. 21 and 300A is still available. Now, that little protection goes away. That also after Coelho, we don't know how your lords, my lords will take that view. What is the scope of challenge under 14, 19 also? That we'll see separately. But under only Article 31C, if 39B is sought to be subserved, only thing Article 31 capital C does is remove the challenge under 14 and 19. Rest of the challenges still remain.
We say that you have no protection of 31C.
Lordships.
Because there's no nexus with 39B.
Lordships.
The law has to then meet the pass muster under Article 14 and 19.
Lordships. The 14, 19 is Lordships, absolutely. But even without that, I still have 21 and 300A. And after KT plantation,
say in Ranganath Reddy's case,
Lordships.
that Article 39B was not applicable. What was the reason given?
Lordships, I can.
That is reversed by the Supreme Court.
Lordships. So,
Why did you say that?
Lordships, I'll take out the High Court judgment. Supreme Court simply says that you have a power to acquire. That is nothing to do with 31C. You have to meet two requirements and two requirements alone. Public purpose, fair compensation. High Court, having upheld both this, should not have interfered. And that's the majority judgment. Therefore, my test of your power to acquire property will be 2 and only 2, nothing else. If you meet this, then all these 14, 19, 21 challenges fall apart. You don't have to go there. That's what the majority says. So it says once I find reasonable compensation and public purpose, it is valid under 14, 19, 21 straight away. All this is all irrelevant. Therefore, we uphold the law.
So they down.
Lordship.
Nationalization of
That's the High Court. Ladyship is right.
The ground that Article 39B was not applicable to the exercise of power.
Lordship.
To that legislation.
Therefore, if my lady permits.
Reasons given for
Absolutely. Is this the High Court?
Yes.
Anything else,
Yes, just one more point. About the legislation, there are two chapters, Chapter 8 and 8A, and that's a little important. 8 cess was imposed from 76 onwards by MADA. The board was set up. 10% I had to pay, that's the landlords, 15% by the tenants of the circle rate. So even if I'm getting some 50 rupees or 100 rupees rent, I have to pay cess on these properties from 76 onwards. And the reason for the cess was that MHADA will collect the cess and repair all these buildings because I'm not giving you rental. I hope I'm making myself clear. And therefore, Chapter 8 put the obligation on MHADA to find out are the properties dilapidated. MHADA was given huge chunks of land. They have some 2,000 acres, if I remember correctly, of land given. MHADA had to carry out these repair obligation, taking money from me. So 10% of circle rate I pay, 15% tenants pay. MHADA collects that money. They have to come on a yearly or whatever, a certain period, they have to come and check the value, the strength of the building and whether it's dilapidated. It was MHADA's duty to repair and then give it back to the landlords and the tenant. MHADA, and those reports are also on record, MHADA comes and says we are incapable of doing this, although we'll continue to take the cess. That's why these are category A cess building. So they keep taking the money and say we can't do anything. And then they say, because I have failed, now I will give it to the tenants. That's what has happened. And now the requirement of dilapidated is gone in Chapter 8A. So any building, 70 occupiers may not even be tenants. Occupier definition is something also very challenging. Go ahead and say now whoever some trespasser is sitting there, he's part of 70%. He'll come and say, I wanted your building. You spent a lot of money despite no rent. You kept it up. It's in great shape. But I want it. I will take it. That's Chapter 8A. In fact, the purpose, if 39B there was a purpose, Chapter 8 satisfies that. Namely, MHADA has to spend money which they recovered from us to maintain the building. That would be public purpose, no difficulty. Now what they're doing is we are incapable. They have given a report saying we are incompetent and incapable, and I mean my word's not there, but they effectively say that and say therefore you allow them to take over. So that's the situation. Therefore, Chapter 8 I can understand says subserve public purpose, we will repair if the landlord is not doing. And this whole situation is created by freezing the rents. Now, if you give me freezing, even if you froze the rent, if at least you had given me the ability to raise the cost of my repairs, I would have carried out. You block me in every way, then you charge me cess. So I am getting almost nothing by rent. Then I'm paying 10% of circle rate to the government for repair of my building, and then you say now repair or not, let the tenant take it away. Now, can an act of this sort be protected by 39B? My submission is no. 39B has to subserve the public good. Public good will be, Lord the Chief Justice mentioned, if you want to protect buildings, I understand. Now, does 8A say that only dilapidated buildings will be taken over? No. They say any building that 70% of the tenants want. Now, therefore, it doesn't even subserve any purpose. What is happening is just unfair. For 85 years, my rents have been frozen. I am obliged to keep my building in maintenance and good repair, but I am not allowed to collect the money. And in addition, I have to pay the cess. And MHADA says, I can't repair it, so now give it away. Now, these are all hard-earned money. All the reports, in fact, when we go to the smaller bench, 5 judges or wherever my lord send us, we'll point all this out. Their own report says, most landlords have put every bit of their hard-earned money to make their house. They were relying on the income of this house to sustain themselves. Most of the landlords, specifically these buildings that we are concerned with, none of them can fend for themselves. In fact, the landlords here are the ones who are poor because they do not have even access. Yeah, but I said this is what I'll be arguing, so I'm entitled to say that. So therefore, I'm submitting that we will be submitting that in fact the 39B purpose is not subserved in any way. This is your, so to say, conduct, and if I may use the word politics of the state, that has created this situation where you're punishing me for your own failures. You are unable to, and there are the presidential assent that the respondents so strongly rely on. The presidential assent says, I'm giving you this assent on the assumption that you will raise rents in future. This honorable court in Malpe Vishwanath Acharya said that you will raise rents in future. There is a model, the union government, the parliament has passed the Model Rent Act, which says over a period of time for these old Rent Act provisions, over a period of time, the rents will be increased so that over 10 years, 5 years, you bring them in line with the present rate. Now, making this MHADA, it will be completely unconscionable to allow a law of this sort where the failure is of the legislature not taking care of the situation, not taking care of the problem, and their own default they want to correct by taking away my property. That's the situation. Can it at all be covered by 39B is our submission. And therefore, once you see 39B in the context, namely directive principles obligations of the state. These are not my obligations, they are your obligations. And you're in breach of your obligations under Chapter 8. And having failed in your duty to maintain these buildings, now you can't trust Chapter 8 ends and now you 100 times monthly rent, not even yearly rent. 1 month's rent, 100 times, so 50 rupee rent, give 100 into 50.
40.
Sorry, rent is of 1940, I'm obliged. You pay 100 times 1940 rent, and we put all the wholesale price index, etc. The prices, just the inflation has gone up more than 1000%, 1000 times or something. And of course, the rental prices have gone up. And this is, in fact, and my lord, the Chief Justice, I had to respond to your question. All the reports of the government, respondent state government say that in fact all these provisions are the one affecting the housing stock in Bombay. Nobody is ready to build, nobody is ready to maintain, more supply is not coming because you've created a situation which is unsustainable. So to answer the question, and of course we'll take that later, but to answer the 39B question also, these acts, these which are under challenge, are the cause for the problem, they're not the solution. In fact, if they act reasonably, make proper changes, etc., the housing stock will increase, the tenants will have the money, landlords will have the money to repair them, keep them in good repair as they do it in other places. And therefore, just to summarize and conclude, my lords, our submission is 39B must be seen in the context of the entire constitution. I have all various other rights in the constitution. My land can be taken over in certain cases, no difficulty, but you must comply with all other requirements of the constitution. By this method of 39B, you say, now I want to distribute your land to some other private party and I've taken it. That's not the interpretation that a constitution like ours can sustain. It must be, it may be in a Marxist constitution, certainly you take everybody's land and make it a communal land. And that's the Marxist theory. Certainly not under our constitution, which still has 300A, which possibly might be a higher right than the rights we had earlier, because now the right to property in KT Plantation judgment, my lords have actually said that the 300A is now a higher right. It cannot be suspended at all. You cannot give illusory compensation. You must give a fair and reasonable compensation. You must have a public purpose. Then you can acquire a land, no difficulty. But therefore, I submit, my lords, in conclusion, that 39B, please interpret it in a manner that subserves the purpose of the Constitution. Read it holistically, read it all the provisions of the Constitution. And certainly the only conclusion that can come is this is a duty of the state. It is not the power to take away a private party's land and give it to another. So that's with that, my lords, I'm deeply grateful. So we need to say what?
Got extended.
That extent.
Lord, before we had divided the work, Lord, I had myself prepared a small note on this aspect. Lord, I've taken the liberty of having it uploaded. But my Lord, may I first address your Lordship on two aspects?
Yes.
Or may I address your Lordship on two aspects before going there? But the first is I want to make some arguments in support of what my learned friends have said. Lord, the second is I want to argue a point on demurrer. Lord, I want to argue a point accepting that theoretically and academically it is possible that property could form a part of 39B, but that if you accept that, the distinction between private property and public property must effectively be at vanishing point. Lord, so I want to address that second argument before your Lordships as well. So not these two. Lord, I believe, Lord, that no real reading of the directive principles chapter can really be understood, Lord, without a preface. Lord, as your Lordships are well aware, Lord, that at the time of the Constituent Assembly and the formation of the Constitution, Lord, it was always envisaged that directive principles would be very much on the same footing as fundamental rights. Lord, the often colloquialism which is used is to say that fundamental rights are somehow superior to directive principles.
Right. Said that these are two wheels of a golden
Exactly. And therefore, my Lord, it is always a matter of balance when we go to the directive principles, they've always got to be balanced with the other provisions in the Constitution. But I think it is also important to remember, Lord, that till 1978, we had the entrenched fundamental right of property, Lord, which was in 19(1)(f), Lord, and 31, which took into account the concept of eminent domain, or that if property is to be acquired, it could be acquired, Lord, only for a public purpose and upon the payment of fair compensation. Now, Lord, that came to be deleted for entirely different reasons, Lord, in 1978. But when your lordships look at 39B, in my respectful submission, it is important to bear in mind that that is how the Constitution first looked. So on the one hand, we had the right to property. On the other hand, we had what was undoubtedly a social charter in the need, to my Lord Justice Dhulia's point, to alleviate inequality and to distribute property. And any construction that we arrive at of 39B, in my respectful submission, must take into account this context. I'm not having said that, Lord, may I request your lordships just to see the section with me for a minute. Lord, I just want to point out to your lordships that there are three material parts of the section. But the first is what is to be distributed. Lord, is the ownership and control of what is to be distributed. Lord, is the ownership and control of something else. So there are two particular indicia of that something else which is to be distributed, ownership and control. And what that is one compendious composite expression, the material resources of the community. Not the latter part is that the distribution is to subserve the common good. But that's not so important for the purpose of the current reading. But Lord, it is my respectful submission to your lordships that, Lord, on my demurrer argument when I address it, that my Lord the Chief Justice, Lord, was not entirely wrong. Lord, I think, Lord, it would be futile and academic, Lord, to try to oppose a conceptual argument that it is possible that private property can be introduced into the concept of material resources of the community. But the real question to my mind is, what is the nature of that private property that will fit within this compendious expression, material resources of the community? But we know that it must have certain characteristics. Because it must be material resource, and Lord, I have some definition to show your lordship of that, and it must be of the community. So Lord, my learned friend's point, Lord, my learned friend's fees from today's appearance, your lordship said distributed through taxation, separate provision for that Article 265. When my lady spoke of land acquisition, separate provision from that originally. But and interestingly, in Bhim Singh Ji's case, Lord, there was a challenge actually to the Urban Land Ceiling Act. The challenge was on the 39B grounds, and actually it was negative on the grounds that the 31C protection was available on the ground of 39B, as I'll show my lady also from the High Court. Actually, Justice Untwalia's judgment refers also to the challenge in the High Court, which I'll just show my lady in a minute or so. But not to come back to this point. But if we acknowledge the fact that private property can fit within the expression material resource of the community, it must satisfy all these requirements. It must be private property which has the characteristic of being a resource, and it must be a material resource of the community. I'm not having said that, my lord. May I show your lordship my note? My lord, I've made some submissions in my note. And Lord, please bear in mind, my lord, my note was slightly focused on a different point, and that's reflected in the chapter, but it really addresses this point. Lord, or it is in the morning Google link at 9 o'clock or so, which was sent to your lordship. It's called Chapter 8A does not receive the protection of the... sorry, just now, okay. Okay. Oh, thank you. Your Lordship, sir. But para two, Lord, but para two is what I've already, in fact, Lord, made some submissions to your Lordship on. But can I take your Lordship straight away to paragraph 4? Yes, please, Lord. Yes, my Lord. Yes, page 48, that's right. But and if I can actually, my Lord, to my Lord, the Chief Justice's point, para 2 actually, my Lord, states it a lot better than I said it. My Lord, may I just read it to your Lordship? Or paragraph? Sorry. My apologies. But can I just read to your lordship paragraph 2, my lord? But state policy in Article 39B has 3 ingredients. There must be a material resource. More importantly, it must be a material resource of the community. To my Lord Justice Bindal's point, not something which I'll just develop. Lord, if the material resource is not of the community, it is not the subject of the policy. There must be a distribution of the ownership and control of the material resource. Article 39B does not say that the material resources are to be distributed. Mere distribution of material resources without distributing the element of ownership and control is not the subject of policy. So, my lord, the distribution, as I mentioned to your lordship, my lord, is with regard to ownership and control. The distribution must be such as to serve the common good. Distribution which does not subserve the common good is not the subject of the policy. My lord, I'll then skip minimum of this. My lord, please come to paragraph 4. Now, my lord, some dictionary meanings, well, because we don't have any actual legal construction of these terms. Material resource. The dictionary meaning of resource and resources is a means of, your lordship, sir, there is a means of supplying a deficiency, a stock or reserve, which can be drawn or when necessary, available assets. In plural, the collective means possessed by a country for its own support or defense. Example, countries with large natural resources. So, my lord, that's the definition, my lord, with regard to resource. It's normally used in the context of community. And, my lord, sometimes in plural, it is used in the context of state property. But it doesn't preclude it being also of private ownership, as I'll come to. My lord, resource, something which lies ready for use or that can be drawn upon for aid or to take care of a need. The plural is available money or property, wealth and assets. The plural is something that a country or state, etc., has that can be used to its advantage, natural resources including coal and oil, a means of accomplishing something, and that's what Webster says. Now, Lord, Article 39B uses the plural resources, which brings in the national or community aspect of the meaning of resource. That this meaning in Article 39B is evident from the qualification of the community in the article. The meaning of the word community itself is a body of persons. The word material as an adjective in this context means important and essential. Material resources of the community can therefore mean natural resources, illustratively, which are those of the country or the nation, or the means of production, which in a large sense can be said to be of a community, even though they are in private hands. The concept negatives any property in which there is no interest of the community. Lord, in Karnataka and Rangariri, Lord Justice Krishna Iyer cites the meaning of resources from a dictionary, from Black's dictionary, and says this: Lord, money or any property that can be converted into supplies, means of raising monies or supplies, capabilities of raising wealth, or to supply necessary wants, available means of capability of any kind. This definition is no longer found, Lord, in the dictionary. It's not available. By itself, this definition cannot be applied to the concept of 39B, as it does not bring in the interest of the community as a resource. But then I've cited, my lord, the observation which your lordship already read. I pointed out that it has been followed elsewhere. And not in 4.10, Lord, what I've said is this, my lord. This formulation of material resources is too widely stated. Private sources of meeting material needs are not material resources of the community. Not everything of value in the world is a material resource. The Constitution does not embody a political or social theory that because the individual is a member of the community, his resources, however small and humble, are necessary part of the community. So, my lord, that is, my lord, an interpretive argument, my lord, based on this aspect of the matter. Lord, just one last point that I have for your lordship. Lord, to become a material resource of a community, a particular class of property must have some homogeneity, or it must have some common characteristic. Not the housing stock that is under rent and subject to MADA acquisition is of the most diverse and varied kind. Lord, if your lordships were to go to Bombay, my lord, to perhaps what is the most affluent area of Bombay, Carmichael Road, your lordship will find, Lord, extremely wealthy people living in lavish style in, Lord, well-appointed buildings. But on the other hand, if your lordships were to go to some of the ghettos of Bombay, your lordship would find people almost at the point of destitution who are also tenants. My lord, so the housing stock lacks a quality of homogeneity. But it is not possible to say that in every case, the housing stock which is the subject of acquisition under 8A can have a homogeneous nature, and therefore, Lord, in my respectful submission, can never fall within the definition of the material resource of the community. I'm obliged to your lordship. Thank you.
My lord, before coming to this, you got material resources. I will go to this Article 366(12). Goods, where the definition, because if we have to enlarge the definition of 39B to include everything, which will include a good also, all material, commodities and articles. It means by way of this interpretation, all material resources are different than the goods. So therefore, now the advancement of the Constitution of India and amendment now kindly have 17th amendment, because the right to property was always a thing which was being taken away. Now the 17th amendment, when came to 31A, when the provision was made, if you have to take the property of someone, make the payment at the market value. That was 17. Therefore, that comes the 44. And the third one comes the 73rd Constitution Amendment, which has made the country three-tier system. And in relation to that, I will be making my submission. My lord, may kindly have 31A, only to the extent of market value. 31A proviso. Provided further where any law makes a provision of acquisition of a state, comprises land, personal cultivation, whatever. We know that urban land ceiling has gone. So there is no, because when we go to the Keshwanand Bharati, that was the concept of creating a new public order or social order. Now with the advancement after 75 years, we are into a different era, and we have come from nationalization to disinvestment. So the meaning what was there, because at that time when we interpreted these laws, Article 31 was there. After 44th Amendment, Article 31 has gone. And that time, 19(1)(f) was there. Right to property was a fundamental right. After that, now it is Article 300A. So that, to that extent, kindly have 17th Amendment, which says you have to pay the market value. Now, after that, my lord, kindly have the Article 243G. Because after 73rd Amendment, the power has been entrusted to the local self or the public good, the public of managing the utility or any good. To that extent, my brothers who have placed the subject. Now 2 chapters have been added, Part 9 and Part 9A of the Constitution of India. Power, authority and responsibility of Panchayat. This is for common good, not by giving it to the hand of certain number of persons by acquiring. Now, my lord, I pause for a minute. My lord Justice Manoj Mishra is there. My lord Justice Dhulia is there. And even I have done some cases where the properties under 20-point program were given to certain persons. They paid some money by getting it transferable right and they sold it. This is the hard reality of the era. Kindly have power, and I'm coming to these two point A or B, subject to the provision of the Constitution. The legislature of a state may by law endo panchayat such power and authority may be necessary to enable them to function the institution of self-government, and such law contain provision of devolution of power and responsibility upon panchayat to appropriate level, subject to such condition as may be specified therein. Preparation of plan for economic development. This is 39B. And social justice. Second part, implementation of a scheme of the development. What has been done in the state of West Bengal, retrospectively from 1969, in the year 1981, definition of land has been enlarged to include mill, factory, even the religious institutions have been brought in within the definition of land and apply with that. So to that extent, what I respectfully submit, whenever 39B comes, there has to be a distribution by whom? Now I in the backdrop of this, I read Article 39. And then I will come to the Schedule 11 and 12. In Bombay, the Act, one of the features is the slum, which comes under Schedule 12 in the Constitution of India. So we are interpreting because in Sanjeev Coke in para 20, this Honorable Court said, you cannot take the under 39B, you cannot take the entire industry. There is a clause. So therefore, you cannot make a person without livelihood. Now, concept is this. I will read two paragraphs, 239A, B, the ownership and control of all material resources. If the material resources is a good, then the material resources is something different, which is to be used for a common public, for a common larger benefit and interest, not for the merely purpose of living or housing or just for the purpose of making the social standard. It is something very, very, very big step, which has to be because at the time of the nationalization cases, certain companies were in the hand of Britishers.
What is the point that you are trying to?
I'm taking it now. What I submit. Number one, material resources is a word which is to be used in a very careful manner to include only the resources which are essential to the society and not the private properties.
That point has been made.
Now, two, concentration of the wealth. Concentration of the wealth, not by taking away the right of a private person, depriving his right to livelihood and give it to someone else. Applying the ceiling limit or applying a house or taking away the right of a livelihood of someone, the concentration, suppose in the West Bengal, the ceiling limit has been imposed with effect from 1969. Now, after that, the ceiling limit with the retrospective effect, our houses and property, mill, factory, everything is being taken away. So that to that extent, in that context, what is the concentration of the wealth? Now, in my written submission, I have dealt with the definition part. I leave it to that. Now, second submission, which I am going to make, my lord, 300A, right to life, with the right of livelihood, and 300A, because now it is a constitutional right. Now, constitutional right is a right after the advancement of so much of the jurisprudence of the property. It cannot be taken away on the name of merely concentration and applying the yardstick, which was in the year 1971 or 72. For that purpose, I merely read one paragraph from Sanjeev Coke.
What is the point that you are making now?
Now, the concept I am making, this Honorable Court never approved that the state has the power to acquire everything at their own. 39B, rider came in Sanjeev Coke. The Learned Council, page 2317. The Learned Council submitted Article 39B would be attracted if the industry as a whole is nationalized, not if only a part of industry. According to him, all the coke, own plant, whatever, they existed to be nationalized. but no privately owned property. We are unable to see any for the distribution between public, private and joint sector range of any nationalization state policy inherently inappropriate subject. Scales of justice are not designed to weigh competing social economic factors in such a matter. Legislative wisdom must prevail with the judicial review must abstain. To that extent, what I respectfully submit, the right to property, which is which is now a constitutional right, does not come within the purview of material resources. That is my submission.
Property is not a material resource.
Property, if owned for a livelihood, if a person is having a property which is not for livelihood, other than for livelihood, there has to be a distinction between a livelihood of a property and a property which is not for livelihood. Suppose in Bombay, I have one house and that house has been taken away. That will not be for the purpose of common good by depriving me from my right of livelihood.
Can be. Suppose if you have a house in 200 acres, then it will be taken away.
My lord, house for my right to livelihood, then Article 21 survives.
For equal distribution.
Then the law has to be there that nobody can have a house of more than 50 yards. Equal distribution, including me, not by taking away my right.
Thank you, Mr. Sharma. So tomorrow morning, we'll start with the Learned Attorney General. Tomorrow morning.
Lordships, if I may just have 10 minutes of your Lordship's time.
Sorry?
Look, we just want to make very brief submissions tomorrow morning, 10 minutes, between the two of us.
All right, 10 minutes in the morning, and then
We'll share.
Great. The notes and compilations sent by Mr. Andarujana and Mr. Devarajan are without volume numbers. So please make sure that you put them all together in volume numbers, otherwise we'll never know. You can actually put yours as, give them specific volume numbers and then share it with the other side, so that they will also know.
By Lord's kind permission, because a lot of what we have written, we have been asked not to get into it. Can we edit them and send it to you, my lords? Because see, we have gone on the basis that 31C we could argue. Lot of matters are related to 31C. Now we have not been allowed to argue that.
And, but do it by the evening today. By 8 o'clock in the night, give it to the court master.
Good morning.
And you can send a message to the court master when you have added it. Otherwise, he doesn't know that you have added it.
I'll do that.
Right? So by 8 o'clock, make sure all the edited compilations in volume wise are available with the court master.
Please.
Yes, certainly, Mr. Grateful.
Obliged.